appeal has been disposed of. Appeal is pending.
Appeal is
Your money is there.
my lord.
What is the problem in
There, my lord, I tell you, lordship, my lord, the statute.
Mr. Nag, please enlighten me on this, because you have been dealing with this. What is the process for getting the order passed by the estate officer executed?
My lord, I tell you, lordship, my lord, what is the
How do you execute the order passed by the estate officer? This
Under
is a
section-
step in execution.
yes under section 5? Under section 5.
What is the process? Are they entitled to notice, or they are not?
No,
entitled?
they are not entitled to notice. That I can. My lord, kindly have a look at head of course. Hey, hello, wait. Hello, wait.
Direction coordinated to the estate officer to release the goods.
Hmm?
Sir, the direction coordinated to the estate officer to release the goods.
আছে কই আগের ম্যাটারে ছিল, এখানে নেই, আগের কোর্টে ছিল।
I have handed over a book to for.
দিন আমাকে ওনার বইটা দিন, দেরি হচ্ছে।
No, my lord, lordship, first is the section for notice on the basis of my application. Then, my lord, kindly come to section 5.
Yes.
Now, my lord, here in section 5(1), my lord, eviction order is passed after the process. Now, my lord, the what lordship's query is 5(2). If any person refuses or fails to comply with the order of eviction on or before the date specified in the said order, within 15 days of the date of publication of such and such, the estate officer or any other officer duly authorized by the estate officer in this behalf may, after the date specified or after expiry of the period as aforesaid, whichever is later, evict the person from take the possession of the public premises for the purpose, use such force as may be necessary. Then, my lord, the provided if the estate officer is satisfied for the reason to be recorded in writing, there exists any compelling reason which prevents the person from regulating the 15 days, estate officer may grant further time. Now, my lord,
So
there
this is when the
Refuses
estate
to-
officer takes steps strictly in compliance with the section, and there is no order of stay. Now, in this situation where you had said that you will not execute the order, you had granted them time in excess of 15 days, in a sense, by saying to court that yes, going by your expression, at this stage you will not
at
take
this
it.
stage.
Now, yes, at this stage you
That's
will
a-
not be taking steps. Now, there is a confusion as to what would be the meaning of the expression at this
At this
stage.
stage.
What will be the extent of the stage?
My lord,
Will it,
there's also
will it-
another episode in this matter, because here they basically why
Will it not be proper then that when you are going to take possession, for example, you take the proviso which says that yes, you will grant another 15 days time to them. Would it not have been proper on your part to put them on notice again that see,
that, my lord,
you
that
have
that is not in the statute. I understand what
the
is
undertaking was also not in the statute.
undertaking was
Undertaking was
my
also
lord, as
not
a
in the
matter of
statute.
fact, undertaking was given without any authority. And my lord, I tell you, lordship,
Whatever it is,
the
you have
background, my lord,
you have lived up to the undertaking for so long. All on a sudden, if you suddenly go and lock the premises of somebody, putting him out, forcing him out,
It is, my lord, one thing, my lord, 1 minute. My lord, it was not all of a sudden. They were enjoying basically an order of stay in a suit in respect of self-same premises. The petition of before your lordship. Now, this suit was dismissed on an application under Order 7, Rule 11, an interim order vacated.
when
Just before that, I tell your lordship, just grant me a moment. And on the when this interim order was vacated, my lord, we went there and took possession. It's not that all of a sudden, my lord, the interim order was subsisting till, my lord, from, my lord, 23rd 12/2024, and Order 7 Rule 11 order passed on 23rd June 2006. Now, order ta copy. Just I am handing over the copy. And when it was
after 20
Order 7 Rule 11 এর copy.
23rd June 26 এর অর্ডার কি আছে
23rd June, my lord, the suit was dismissed, and thereafter position was taken on 1st July. On 1st July.
কোন সুট
Suit filed by you.
সুট
Yeah. Filed by you.
That is.
Suit filed by you, my lord. I am handing over a copy of, my lord,
কে sign করেছে?
Order 7 Rule 11. Order 7 Rule 11 copy of the order. এই একটু হ্যান্ড ওভার একটা কপি আছে একটা আদার সাইড দাও এনো মানে লর্ডশিপ সিজ the order dated, my lord, 23rd June 2026. The record is fixed today for extension and hearing of such and such. A lot of opportunity given, written objection, learned advocate defends the suit, instance suit has been filed, declaration, injunction, and whatever. The defendant number 2 is a statutory body, governed under public defendants. Also states court has no jurisdiction in the suit, but had the considered the purpose of provision is entirety averments of the plaintiff has to be on careful perusal of the plaintiff. It can be found the plaintiff, he has stated he is a lessee in the suit property used to pay charges from the plaintiff. The plaintiff is evident himself admitting the suit property is not direct connection with the defendant in Kolkata. There is no doubt to hold under section 15 quoted, and then so from the averments of the plaintiff is evident it is barred by the Public Premises Act. Thus this court is inclined to allow the petition defendant and, my lord, the order without cost stand disposed of, non-maintainable. Interim order, if any, stands vacated. So the interim order which was there for last 2 years were vacated. Now, my lord, this is the reason they did not, my lord, when the suit or appeal was transferred, my lord, they did not renew their prayer for interim order in the appeal. This was at this stage, and thereafter went to other judge, and they never renewed it because they were enjoying an interim order. And then when interim order was vacated, then, my lord, on 1st July we took possession. Now, my lord, lordship, what has fallen from your lordship is absolutely correct. It should have been, but the statute does not mandate that. Also, my lord, kindly have a look at section 7 of the rule. Section 7 of the rule, my lord, if lordship takes
রুল বলছো না অ্যাক্ট বলছো? তাহলে রুল
Rule
7
7.
বলো।
Rule 7. Now, my lord, these are the two provisions, my lord, as far as my understanding. Manner of taking possession of public premises. If any obstruction is offered, as your lordship got that, is offered or is of the opinion of the estate officer likely to be offered to taking possession or to stealing or erection work under the estate officer, other officer duly authorized by him in his behalf may obtain police assistance for sealing and such and such. So if any obstruction is offered, then I can take where any public possession under such and such found lock such and such. Now, my lord, this is the possession. Now, my lord, under section 6, kindly have a look. I have placed that before your lordship. Lordship has also considered in other matter. Now, my lord, lordship sees section 6, the disposal of the property. So if I take possession in the APL judgment, which overrules the special bench judgment of this honorable court, this clearly says now it is the domain of the estate officer. You go apply, estate officer, if feels he will release that. So kindly look at section 6 and, well, at APL judgment. I understand what has fallen from your lordship. I do not have a good case on merit. But whatever law is law, my lord, I am just placing it. My lord, don't take me amiss. My lord, kindly take section 6, my lord. Where any person, may I place it, my lord?
No, but where is the proceeding to show that section 6 has been invoked by you?
That, my lord, the estate, whatever
What was the time granted to you?
yes,
Mr.
yes, of
Sarag?
course it has been,
Because
I am
during
told, my lord,
pendency of this, now you invoke section
my lord,
6
I
and
tell you,
you say that
I tell you, lordship, as far as my, it's not clear instruction, if I don't get, my lord, statutory, I cannot convey that to your lordship, that the process has been initiated before the estate officer. Within this short time, we could not on Monday ask him to file a report before the court. I am inviting your lordship.
by Monday you will invoke section 6 and
No,
say
no,
that
no.
for the
If it is
court.
in between, your lordship will set aside that process.
So ask him to come at 12. and
Yes.
inform the court.
My lord,
that-
may I have 5 minutes, my lord, to address, my lord? I don't need, my lord, the authorities, my lord, mercy here. I am here before the court to show the conduct of the authority. It is not that lordship gave him only 24 hours. My learned friend got, my lord, from 13th of July time to take instructions. It's a deliberate attempt on behalf of my learned friend's client not to give proper instructions to the either the advocates or, my lord, they don't indicate, my lord, what is the proper state of affairs. Now, my lord, my learned friend relies upon an order passed in a civil, my lord, proceedings. If your lordship sees, my lord, this suit was instituted in 2024. I am not here, my lord, relying upon an order or an undertaking given in a proceeding which was instituted in 2024. I specifically rely upon the order which was passed in my appeal under Section 9 of the Act, where, my lord, a specific undertaking is given by the, my lord, counsel or the advocate representing the authority that we shall not take steps. Now, lordship put a very pertinent question to Mr. Nag. What is the meaning of the expression at this stage? My lord, why, my lord, if we go through the order together, my lord, I'll try and persuade your lordship, what does this expression at this stage mean? My lord, when I file an appeal, by that time there is an execution proceeding. The language used in the order is.
But there is no proceeding. There is no proceeding for execution required.
So, my lord, but the language suggests that they will not proceed with an execution proceeding. The ordering portion of that order.
This stage is also there.
My lord, kindly takes, my lord, the order. It is not.
Two things are there which are troubling Mr. Dotto.
My lord.
One is at this stage. Another is the rider that the appeal should be heard at the earliest.
Yes.
I have seen that there are at least 3 occasions where you have asked for time.
My lord, altogether, I have calculated
No,
there are 9 or 10, my lord, orders after the order by which the undertaking was recorded.
And on 3 consecutive occasions, after the appeal was last heard, time has been prayed for by your client.
Very well.
Kindly see.
My lord, I accept that. My lord, I am not joining issue.
This is something which tells. This is something which tells because the order of stay on, or rather the undertaking not to proceed was given more than 1 year back.
Yes.
It's on 13th of May 2025.
Yes.
Now from 13th of May 2025 till 2nd of December 2025, there are adjournments. The matter was first heard. It was part heard on January 16, 2026. After January 16, 2026, on 26th February, you pray for an adjournment. Matter is adjourned. April 9, you again pray for an adjournment.
Yes.
Matter is adjourned.
Right.
May 18, you again pray for an adjournment. Matter is adjourned. Then on 17 June, you again pray for an adjournment. Matter is again adjourned. And then on 2nd of July.
That's the put up. That's the put up.
That's the put up.
Now, my lord, may I just address on this? Because this is bothering your lordship. The second point. My lord, all the 4 dates on which adjournment has been prayed for, my learned friend was also present. Advocate represented the client, my lord, of my learned friend. My lord,
Estate officer, he's here. She's here.
Yes.
may I just complete my.
Looking at
Take the instructions. Why are the perishable goods not being allowed to be taken out?
There are, my lord, medical items. There are perishable goods. There are other. Why can.
Yes, please.
My lord, on the point of adjournment, my lord, they were present. It is not that the 4 adjournments is the ground on which.
It's not that.
It cannot be, my lord.
Mr. Dotto, it is not that the.
Lordship is looking at my conduct.
Yes.
Lordship can put me on terms there that I will direct the, my lord.
My lord, estate officer handed over is marked. She has passed an order for releasing of perishable goods.
There is an
They are
order passed.
I don't have anything, my lord.
Take them. Go and get your goods.
My lord, it's under padlock. I can do nothing, my lord, there.
She has passed an order. They'll facilitate.
Estate officer.
Facilitate.
My lord, this is, my lord, these are 24th July.
There now. Let us not.
Act minute.
Let us
My
not.
lord, let me just go through this document. Gives me a minute.
My lord, I am appealing for authority. I will not take any chance, my lord. I have asked her.
In Amgulo, ठीक.
Yes. SPMK is hereby directed to release return documents, perishable goods.
Including motorcycle. There is a garage of
Yes.
motorcycle which was searched for servicing purpose.
We have our capital goods there.
My
We are carrying on business with respect to certain computer parts. The parts are lying there. My shop, we are These
Please
are
read
not
third paragraph of the
Lordship.
order.
They are not doing it. There are various
Do it.
reasons.
They have said so.
There are reasons we have on record.
Very well. Now you have a letter unnecessarily instead
Lordship
of
would
fighting.
kindly
Why are you not
clarify.
doing? This is going to be on record in today's order.
My lord,
Lordship, we have
sees the
tried.
third paragraph. Sees the third paragraph.
Only those goods are-
It is only, my lord, conditional. My lord, it
What is
says, my lord, perishable goods and materials and return of documents for official business.
Yes.
What authority does, my lord, port have to, my lord, retain the other nature of goods?
100%. I will argue on that. There is a judgment.
If he argues on that, my lord,
That is
kindly.
judgment of
Mr.
Supreme
Datto, now
Court.
let us not enlarge what you said
No, no, no.
yesterday. Yesterday, the instruction was only for the purpose of perishable goods.
My lord,
It
perishable,
is there.
I
It
said,
is-
my lord, perishable and non-perishable goods,
No,
both are lying
you
there.
said perishable. My instruction specific was for perishable. That was, I remember what I said. I remember what I heard. You said perishable. I asked him to take instructions on why perishable goods will not be released. There is an order saying that perishable goods will be released. Now, if you are satisfied with this, we can proceed further. If you want to argue,
No,
then
I
this
am,
has to go
my
before
lord,
the
so far
revision.
as this is concerned, my lord, I will take this, but I am trying to, my lord, request or make a prayer before your lordship that what is, my lord, prompting the port to, my lord, retain on the other goods which is lying, my lord, which is
That
not
argument-
concerned
that
with,
arg-
my lord,
That
the
argument will
judgment
be an
debtor.
That argument will be an argument on the revisional application itself on merits, Mr. Dotto. When the entire order or the entire act of the port authority.
My lord, question here in the revisional application would be, my lord, subject to being corrected, my lord, that whether the action of the port in, my lord, breaking open the padlock and taking forcible position is correct or not when an undertaking was given to court. Now, lordship
The
was, my lord,
undertaking,
lordship
Mr.
had
Mr.
pointed out
Dotto,
two.
the undertaking is again hedged by two conditions, one of which is in the domain of interpretation. We will not go with it. The other is on your client's conduct. Your client's conduct shows that you have tried to take advantage prima facie at least of the undertaking given. Why on 3 successive occasions you have gone on taking adjournments?
May I just indicate this, my client stand today. Lordship can record as, my lord, a submission of the advocate, my lord, for the, my lord, petitioner. I don't want to delay the hearing of the appeal.
Then you should not have delayed.
My lord,
It has apparently been delayed for at least 6 months.
My lord, it has. The records show it has.
Yes,
But
6
it is
months.
not that the port is aggrieved by the adjournment. Otherwise, the port would have taken steps. My lord, just because there are 4 adjournments.
Dotto, putting all your arguments aside, port will be aggrieved because the order dated 13th of May 2025, which recorded the undertaking given by the port, has also recorded that the port wanted the appeal to be expedited.
My lord, then what would have been the
Appeal could not have. No, what is again for you also? What could have been done by them is a question. What should have been done by them is another question.
Lordship
then.
is looking at the conduct
when
of
we are
both the
looking at-
parties today.
Yes, then we are
Lordship
looking
is
at
balancing the conduct
yes,
today.
then we are
My lord,
balancing
there is no
equities.
application.
Mr. Dotto, when we are balancing equities, then in that case, once you expect equity, you should also do equity.
My lord, I say I will do. I will have the appeal heard.
Therefore, today now you will have the appeal heard. That's all very good. Today, it was under to be mentioned only to see whether perishable goods can be released or not. There is an order saying that perishable goods will be released, and whatever is there in paragraph 3, they will be bound by whatever they say. You take back your goods.
So, my lord,
and
there would
argue
be
on
other
that.
category of, my lord, traders whose
No.
goods will still be, my lord, lying in the godown, which would be, my lord, refusal of the prayer which I make today before this court. I am only, my lord, on this. If the undertaking.
On the hearing of this revisional application, Mr. Dotto, you mentioned it on that day, saying that this is the urgency. Maybe the port authorities will come and say that no, we had.
My lord, possibly I am not in a. Possibly, my lord,
Then
kindly
in
gives
that
me 2
case,
more minutes to
then
explain
it
myself.
should go
I
before the
I
regular
will
bench.
accept this, my lord. I cannot today say I will not accept this.
As to be mentioned, it was not brought with the purpose of hearing.
No,
of
I don't want that, my lord. But kindly.
exactly that you want.
No, my lord, I don't want that. Kindly do not misunderstand me, my lord. My only, my lord, purpose is, my lord, so far as perishable goods is concerned, my lord, this order will help the traders who have perishable goods lying there. I am here only to request your lordship. I can only make a prayer, and it's up to your lordship to grant that relief or not. My lord, there are other, my lord, traders with modest means, my lord, whose goods are still lying there. Why is it that, my lord, the port will not release those? They have taken possession. Why is it that goods will not be released?
So far as other small traders are concerned, their livelihoods will be at stake.
Exactly.
My lord, I tell your lordship. My lord, I have argued that before your lordship. My lord, why we are creature of statute.
Very well.
Well,
If they make
Section 6
applications,
process,
if they make applications to you,
that will
for
be
release,
considered.
no, not only considered, please consider it in the right earnest. Mr. Nag as I have been harsh on him, I will be equally harsh on you
no.
also, because this is court
Well-
of equity. You also, right. I am not appreciating the conduct of the appellant before the Learned District Court,
Right.
where the appellant has filed an appeal, got advantage of an undertaking, enjoyed the undertaking, and sought to enjoy the undertaking by taking adjournments at least on 3 successive occasions after the appeal was part heard.
Lordship,
Now, if
Lordship.
this is the conduct, yes, that goes against him. But you being a state authority under Article 12 of the Constitution, you are also to act as a model person.
Of
What
course,
would have been
of course.
the right path to be chosen by a person who answers positively the definition of a state?
Lordship.
You ought to have put them on notice that now see, or you ought to have mentioned it before the learned court, saying
Yes.
that see, they have been taking adjournments successively. Now, please, we had said that we are giving an undertaking at this stage. This is not going to be acceptable to us. If they seek any more
That-
adjournments, and
would
if
have been the
adjournments
ideal.
are granted, then in that case, we will proceed with
Lordship,
section 6.
right.
That would have been a fair conduct. They would have had the opportunity of removing the goods or bearing the brunt of your taking over possession of the matter. So there, why don't you consider this prayer at least till such time that the revision is heard?
May I, well, first one thing, then I will answer your lordship. Well, can you look at the prayer of the civil division lab? This is
Civil
for
divisional application, Mr.
Now
Mr.
they
Nag,
enlarge the
Mr. Nag,
challenging section 6 itself.
no,
They-
it's not challenging section 6. Mr. Nag, if the prayer made in the revisional application is allowed, then entirety of it, lock, stock, barrel goes. They will not have to ask you to release. They will get possession. They will get whatever is there, whatever was there under their possession.
Lordship,
Therefore, if a prayer is big, the smaller is included in it. That's settled. I need not elaborate on that. Now, whatever may be the prayer, since this is not the
that's
regular
why
bench,
lordship
since
can
this is
pass an order that should be considered in accordance with law and sympathetically.
no,
They
you
can
please,
do that.
you please release that.
Yes, my lord.
Unnecessarily
Kindly,
don't
I will,
create
I will leave it there, my lord.
That is
I will leave it there.
My lord, if there is no, my lord, kindly, my lord, I am a statutory authority. I have some statutory predicament. My lord, the lordship has seen section 6 process.
What are the modest
My lord, kindly hears Mr. Jain on this because I don't have specific, my lord, instructions. What kind
There
of
are
trading?
hardware, your lordship, there are capital goods, there are other goods, they are going.
no, the entirety of it can't be that because
Lordship, we will give
then-
we'll give a letter, we'll produce our bills, we'll produce everything to take our goods back. We have everything because GST is involved.
very well, since those goods
everything
are
is
not
there.
perishable, let those goods wait for some time.
Medical
maybe-
equipments are there, your lordship. We have
Medical
to supply
equipment
to
will not expire in 7 days.
we have to, we have
medical
our
equipments-
undertaking, your lordship. We are running from pillar to
Undertaking of what?
post. Undertaking to our third parties.
Well,
We are small
That
traders,
is
your
business
lordship.
risk.
paragraph.
Lordship,
Business
we
risk,
are
that
running
is-
from pillar to post. Your lordship, one
That is
minute.
business
One,
risk. See,
one minute.
inconvenience will always be there.
Lordship, what is
nobody
the
will be
reason?
happy every
At-
time.
My lord, can we,
Whatever-
my lord, can we, lordship was thinking of a workable solution. Can I suggest this, my lord, since lordship had expressed your lordship's mind that lordship will be harsh on me, harsh on the authority
Fine.
also. Because of the, my lord, conduct. My lord, so far as perishable items, documents are concerned, it's clear that they will release. So far as other items are concerned of these traders, my lord, we will supply all necessary documents to, my lord, the estate officer or the officer appointed by the estate officer for this behalf, and we will take it, my lord, back, my lord, showing, my lord, what ownership rights we have in respect of the property. So far as possession is concerned, since they have already taken it, if lordship allows the, my lord, possession relief also, there will be nothing left for the, my lord, first court to appellate court to decide. Sends us back, my lord, whether this taking over possession was correct or
Mr.
not.
Nag, that is a
With
fair
this,
question.
my lord, relief, kindly, my lord,
Hear me for 1 minute.
Lordship.
He'll make a representation. I'll direct you to consider the representation not ritually or religiously. I will ask you to consider it in the right earnest, considering 2 things. You had made an undertaking. Adjournments were taken in your presence. You had not objected to the adjournments. This is also something which is quite apparent from the order. There is no
Then
objection
lordship
from your
has to
side.
produce the records that the extension application is objected to or not. Lordship has to
I
see
will
that.
have to go. I will have to go
But
by
in lower
whatever.
court is not
I will have
objection, it's
to
just
go. I
objected.
will have to go by whatever is there in the record of the court, the orders.
Yes.
We are at the prima
Well,
facie
lordship
stage.
knows, my lord,
Therefore,
in lower court, in
no,
trial-
lower court, upper court is
in
not.
trial court, my lord, the objection
There is a
recorded in the
presumption. There is
extension
a
petition.
presumption of correctness of the recording of court.
Lordship.
That is well settled.
Lordship.
Whatever has been recorded by the court is deemed to have been correctly recorded. If you feel that there is some incorrect recording there, you have to approach that court to get it corrected.
Lordship.
That is not the case here. Therefore, whatever is recorded here is recorded here.
Lordship.
Now, in the light of this,
Hmm.
and in the light of your having taken possession, why should you not consider it in the right earnest and release the goods?
My lord, I am a statutory.
If you feel still,
My lord, paragraph
very well,
23, my
very
lord,
well,
looks
very
like-
well. If you
looks
still,
like, my lord,
if
how,
you
what
still-
I can do, my
if
lord.
you still feel that they are not entitled to release of goods, you pass an order.
Yes,
Reason,
we do.
My lord,
Mr.
this would only multiply, because if your lordship keeps this part on the, or gives this authority to the, my lord, court to decide, we understand what is going to be the outcome of that, my lord, process. My lord, I was trying to persuade your lordship that kindly do not give this, my lord, authority to
How
the.
will this court decide, Mr.
No,
Dotto,
this
then
court
as
on
to
the basis, on two basis, my lord, on two basis. Since lordship put me, my lord, only two questions, what was bothering your lordship regarding that undertaking? So, my lord, my point was at this stage would be, my lord, till the stage, my lord, the possession is taken by an execution proceeding. That would cover at this stage, for according to me. Second, my lord, like lord, that was my submission also, the 4 adjournments which have been granted by the court, it is not that court has come with an application saying, look here, it was the understanding between the parties that the appeal would be heard within such and such time. So vacate this undertaking or record that this undertaking will not continue. That is also not their conduct. So, my lord, having not done so, my lord, I am only trying to say, let them, my lord, today. I am not asking for the entirety of the relief today. I am only making a very reasonable prayer. Kindly allows them to, my lord, hold on to the position whether it has been taken unauthorizedly or not, and for the first appellate court to decide that, because my application under 151 for restoration is
Very well,
pending.
then I do
In
this,
the meantime,
then I do this, Mr. Dotto. They have agreed for the perishable goods.
yes,
I will then request the appellate court to entertain this application, because this will entail factual adjudication also, whether your goods that you want to be released, those are so medically important that they need to be released immediately or not. Now, this factual exercise sitting in revision immediately, even I will not be able to do.
possibly the first appellate court will then have the same difficulty, because, my lord,
Why
the
will it
question.
have? It is a court of facts. It is not a revisional court like this court, a constitutional court, where the only area of consideration would be sort of a judicial review, the decision making process, and not the decision itself.
Well, I
I
am
don't
being,
have before
as
me,
the, my
because
lord, person,
you
as
have
the
some
judgment debtor, my lord, who has suffered the order of eviction. My lord, all the traders are on me today, my lord.
the immediate threat of goods having goods perishing, that at the moment has been taken care of. So far as the other goods are concerned, it will be a limited. I will limit the time frame within which, see, the matter was heard on 13th, was supposed to be taken up on 14th. You have waited for 1 week.
I know,
You
my lord.
mentioned it.
I know, my lord. Lordship was very kind. Lordship was very kind, my lord, to.
It's my duty. It's my duty.
Yes.
But now, if I enter into it, this has to be heard. You also will agree that it is not such a matter that I can immediately take a decision. I would have taken if it.
I thought I was making a very fair prayer, my lord, by saying.
that always one thinks when one appears for the petitioner, the respondent will also be thinking in the same way. But the moment you take this chair and you have to balance the equities,
He
it
should.
will become equally difficult.
May I submit
So,
one thing?
He should.
May I submit one thing?
Very competent, he should.
My lord, let's not die.
May I submit one
Well,
thing? One thing.
Kindly permit
Lordship,
him, my
there is
lord.
a
He
fight-
is, my lord,
There
representing
is
all
a
the
fight
traders.
between court trust and my learned. We are under my learned friends. We are occupying space. We are storing our goods there. We have not done a mistake, your lordship.
He's not a finisher.
Mane, we are just,
Yes,
we are
the-
whatever for go down this, we are paying him. And he is, whatever dues are payable. to
I am
him,
under
it is there.
tremendous pressure from all these
Lordship,
traders, my lord,
we are
because of.
small traders, we have small shops. Lordship, I was only praying. We are only praying, your lordship. Lordship would kindly.
now this
Direct
small
release
shop,
of the
big shop, how will I understand? How will I, Mr. Dotto, please try to understand this.
Lordship,
Somebody says, everybody will say that this is my
My lord,
land.
an inventory can be done.
Then we are
Order
going
is
into
there,
exactly
Malad.
the same trading exactly the same path, which I should not, being a
No,
constitutional
at
court.
the first
Lordship
instance,
taking
if lordship,
inventory,
at the
deciding on
first
what-
instance, if lordship feels that this act of the port is not correct, then lordship can, my lord,
There
possibly,
is-
because
there
lordship's
is-
powers are very wide,
There is a gray area. Yes, powers, you
very wide, my lord, and lordship can, my lord,
puff
exercise.
enough air but I'm not going to be blown by that.
I am
That
not
power
doing
is
that,
there.
my lord.
Lordship
I am
would-
not
power
doing
is
that.
there.
I know.
That
I know.
power is there. That
But
power is
in
there.
the
I
order-
know.
Lordship would kindly
There
allow
has to be
removal.
circumstances where this power is to be exercised. Now,
Yeah.
there is a gray area. I have indicated to you. You are intelligent enough to understand this. That when you yourself take advantage of an undertaking on an understanding, implicit may it be, that you will proceed with the appeal expeditiously, and you yourself take adjournments at least on 3 occasions after it being parted. This tells against you.
My lord, even
This
if I
tells
take
against
this to be absolutely correct, my lord, even
Absolutely correct.
absolutely correct, my lord, even then, my lord, the court cannot justify the conduct of taking forcible possession. I
It's
take
not
it.
forcible.
It is, my lord.
It's not forcible at all. It's not forcible because law permits them to take possession under section 6 in such way.
My lord, kindly
That
seize
is
the
why-
provision
that
once
is
again,
why-
my lord. I am still, my lord, entitled to a notice period.
So-
Kindly seize, my lord. My lord, kindly first seize, my lord, section 5. Kindly first seize section 5.
Yes, 5.
I will answer.
কোনটা দেখালো?
My lord, the
My lord was shown 5-2.
Yes.
15 days.
এটা কোন বই এনে দিচ্ছে?
Tenancy Act.
My lord, 5. বইটা দাও না একটু।
My lord, that's 15 days.
My lord,
Eviction
5-2
is in
says
the
if
eviction
any person refuses or fails to comply with the order of eviction. So 5-2, my lord, presupposes that there has to be first an order of eviction and there is a refusal or failure. My lord, this refusal or failure, this situation is not attracted here because of the undertaking which is already recorded in my appeal. So there is no.
There again, the moment you go to the undertaking, Mr. Dotto, you will have to go to the undertaking with all its other attributes. One of the attributes of the undertaking was expeditious disposal of the appeal. I would have understood if there was no adjournment taking, or prior to the adjournments being taken, this possession had been taken away. The moment you take the undertaking saying that it will be done expeditiously, and at this stage I am not going to do it, and then you take adjournments, it amounts to
Lordship is correct, but I hope, my lord, that the Port Authority understood it that way and had taken steps after those 4 adjournments. They did not, my lord, do it. What your
Well,
lordship is thinking
that
is.
is why I say that when I balance the equities, I will have to look at both the sides. From a layman's point of view, yes, it prima facie appears to be very bad. That was my understanding when I heard you also. But when I look at the papers, I have to give some weightage to the papers also. In fact, I have to give all weightage to the papers only. Now there are 3 adjournments. How do you explain this? How do you say that this is a
But
step
kindly
towards
see section 6 once.
this
Kindly
is a
see.
step
I
towards
understand. I
expeditious
understand
disposal.
what's bothering your lordship. And I cannot say my conduct, my lord, in taking 4 adjournments possibly is not, my lord, showing a very good, my lord.
Because this takes you 6 months back.
Kindly see section 6 once.
Yes.
My lord, once there is an eviction, my lord, what is the, my lord, requirement? Kindly see, where any person have been evicted from any public premises under section 5, the estate officer may, after giving 14 days notice to the person from whom possession of the public premises has been taken, and after publishing notice in so and so, having circulation in the locality, remove or cause to be removed or dispose of by so and so. So he can remove, my lord, the estate officer will remove or cause to be removed by giving notice. My lord, pausing here for a moment, this act of taking possession, if, my lord, is ultimately, my lord, the court feels that this is correct in the given circumstances like your lordship is feeling today, then the next question would be disposal or removal of the goods. Then also, my lord, it would go to the persons, my lord, notice would be issued to the person who was in wrongful occupation, and I will inform the traders. My lord,
Under
this
section 6,
exercise,
section 6, if the notice go, the question of payment also comes.
the payment is recorded, my lord, it's already
That
recorded.
is only in respect of rent.
The occupation charges, whatever.
Value of that is there.
Images are there, my lord.
So for
Not
that,
been-
the execution proceeding will have 2 parts. One is recovery of possession.
So in section 6, if you go walk the section 6 path, there will be greater hurdles there, because payment, interest, damages, many other things will come which you need to
My lord, so
then
far as
square off for the purpose.
till the date of order of eviction, whatever was my liability, I have paid. That is recorded. My lord, post that there are 2 parts in an execution. One is recovery of possession. One is, my lord, other, my lord, dues. So far as recovery of possession is concerned, I was trying to, my lord, draw an analogy citing section 6 that once you take possession, your duty is to give a notice of 14 days to the person who was in wrongful possession and then allow him to remove the articles. If that is what the legislature, my lord, has, my lord, felt, my lord, is correct, my lord, why would they not allow the goods to be removed, my lord?
Also right, Mr. Nag, on that. You are supposed to give them notice to remove the goods.
Yes, the paper publication will be there. My lord, kindly look at the order. It's
14
started.
days.
If they are before your paper publication, they themselves are coming and saying
Yes,
that please
they
allow me to
came.
remove my goods.
They came, and in last paragraph, the inventory order of inventory was also there. Lordship says SMPK is directed to file inventory report of the remaining seized goods lying within the period and perusal and records of this forum. It's the order.
So if they go and claim the goods which are inventorized,
Yes.
which are non-perishable, you will allow them to release them, allow them to get.
Provides for that, I am happy,
My
my
lord,
lord.
section 6. My lord, Lordship knows the entire thing. My
I
lord,
don't know.
my lord,
Have to be taught.
initially, the law settled by this honorable court was that I cannot attach third-party goods. Now, my lord, when Supreme Court, the matter went, my lord, Lordship knows APL judgment, it says that I have a right on third party itself. If goods.
Yes, but that is
That-
in a situation, Mr. Nag, there is a difference here. The situation here is there is an appeal pending. They have secured the amount.
Correct.
If they have secured the amount and there is an appeal pending,
Yes.
that judgment might not
My
be imported
secured
here.
amount it's an order of eviction, not under section 7. My monetary claim is yet to be decided.
Then if it is yet to be decided,
Yes.
then in that case, there is no quantum crystallized which they are now required
No,
to
no,
be paid
quantum,
immediately.
my claim is there.
Your claim has not yet been crystallized, Mr. Nag. You will be able to recover only if your claim crystallizes in an order. Your claim is still a claim, which may be adjudicated to be there, may be adjudicated to be not there. If it is adjudicated otherwise, then in that case, you will be putting them in trouble even before your claim being.
It's a domain of the estate office under section 6. Now,
You,
what she will do? Well, let the application be filed before her. She can very well release it. Now, my lord, one.
You show me from the order of the estate officer that there is a claim beyond whatever has been deposited by them.
From the order of eviction.
Yes.
From the order of eviction.
Eviction order only contains the other part also.
My lord, kindly.
It's usually a common
My lord,
order.
civil divisional application was for expeditious disposal. Now they are challenging section 6 as well. Now, my lord, kindly come to paragraph.
That is also right, Mr. Dotto. You have not challenged an order. You want only expeditious disposal.
My lord, I know what, my lord, I have been a late,
Dotto?
I have been a late entrant. I know I cannot open my mouth too wide, my lord. I am really at the mercy of the court, my lord. I have.
Mr. Dotto, now this I did not notice. Now, if you want expeditious disposal of this, that is your prayer.
She passes an order.
My-
Take it back to appeal court.
Record this. You take the perishable goods. You make all your
My
other.
lord, please don't go by the prayer, my lord. In this matter, please don't go by the prayer, my lord. It's not.
Mr. Dotto. These things are dangerous nowadays. No.
Now that your lordship has heard us for so long, my lord, I
But
think lordship had
I
got
heard-
the point, my
I
lord, and
heard-
lordship,
I
whatever
heard you-
best, I know I
I
would get
heard
the
you-
best order from
I
this
heard
court.
you because you prevented me from going to the prayer.
No,
process
that
from
was
the beginning.
that was never my intention, my lord.
I am not saying so, but now since I have gone through it, Mr. Dotto, it won't be proper. Now there are several judgments of the Honorable Supreme Court which tellingly say that if.
But considering the wide, my lord, the authority
Again,
and the power and the jurisdiction of revisional court, lordship, I need not tell your lordship. Lordship knows, my lord, in my lord, given facts and circumstances, prayers
that
can
is
be
there,
molded, my lord, and
then
relief can be
at the
granted.
moment, the urgency has been addressed by this. The further urgency which might be there can be addressed by directing the learned appellate court to take stock of entirety of it. That is
Yes.
your prayer. I am directing. I will be saying that no adjournments will be granted on the first day.
Next day fixed is
28.
next Tuesday.
Very
Next
well.
Tuesday.
On 28th, go and get it heard out. Instead of getting it today, you will get the order on Tuesday. Make the same argument.
As per drafting of the civil revisional application was that they went to the court, say that there was undertaking and on.
Lordship one.
This revisional.
Lordship
So that has also
That is
been
exactly my concern, my lord.
Saying.
I am facing so many, receiving
Now
so
your
many
lordship
calls
is
from
saying
so many traders.
Really.
I have got the best I could, my lord, with this revision. I am very grateful for the order lordship has, my lord, passed today.
Obliged. Grateful. Much.
To my lord, this is my application. To my lord, this is my application, my lord. Lord, this application is arising out of Senior Citizen and Parents Act, my lord. Initially, father executed a deed of gift in favor of his wife, son, and two daughters, my lord. Thereafter, my lord, the two daughters and the mother again executed another deed of gift in favor of the son. Now, my lord, the mother is there is a family dispute, my lord, with regards to daughter-in-law. My lord, I'm not in that. Now, my lord, the mother is mother and father filed an application under section 5(1) before the
আগের অর্ডার আপনি নিয়েছেন ওই
tax and odd, my lord. My lord, that I have annexed, my lord, which is at page 27, Ongikar Patro. It starts at page 25 and relevant portion 27. Last paragraph, my lord.
ইয়েস
তুমি সেই দানপত্র সানন্দে গ্রহণ করিয়াছ, তুমিও তোমার কর্তব্য জ্ঞানে আমার সকল ভবিষ্যতের কথা চিন্তা করিয়াছ। কর্তব্য নিষ্ঠা প্রমাণস্বরূপ আমাদেরকে নগদে 9,50,000 টাকা খোলাপত মথুরাপুর শাখা ইউকো ব্যাংকে তোমার ও তোমার স্ত্রীর নামীয় সাচ অ্যান্ড সাচ অ্যাকাউন্ট হইতে আমাদের সকলের সম্মতিক্রমে আমাদের প্রস্তাবিত 1 নম্বর দাত্রী আমাদের মাতা এবং দাত্রী কনিষ্ঠ ভগিনী হওয়ায় ওই একই শাখায় ব্যাংক অ্যাকাউন্ট such and such, but 8 lakhs rupees transferred, my lord. Now, my lord, they filed an application, my lord. Lord, kindly, what I am praying, my lord. Now, the hearing notice was issued, my lord. Lord, the tribunal is not hearing in such as, and my lord, we are not a advocate also cannot represent there, my lord. Lord, kindly permit us regarding the maintainability, because the mother is also some business, my lord, which is at, and I have annexure B, page 24, is a gas agency, my lord, in favor of my mother, my lord, Oruna Gas. Oruna is my mother, my lord, who is respondent number 3, my lord. Respondent opposite party number 3, my lord. So, my lord, section
Why are you not
4 of the
settling with your-
maintenance
why
and
are you not settling with your parents? Why are you fighting with your parents?
my lord, I have tried.
Doesn't look good.
My lord, I have tried. My lord, tried. My lord, so, my lord, I have placed, my lord, that my lord, Ongikar Patro, my lord.
This proceeding taking you anywhere? Fighting with your parents? If you have to
No,
leave something, sacrifice something, do that.
My lord,
That
I have.
that will bring
For
peace
that
to you.
reason, my lord, I have transferred the money in favor of my mother, my lord.
Unnecessarily, you are dragging them to High Court. Will it look good? They have given you birth. They have allowed you to grow up unnecessarily. Why?
That I understand, my lord.
Please,
This is look not good.
try mediation and go and sit. If even you have been wronged by your parents, take it as their blessings and move ahead. How long will they live?
My lord, that's true, my lord.
There
If
will
your
be a time when
lordships,
you will repent, then they
But-
will not be here.
Absolutely, my lord.
Don't do that.
My lord, I have tried, my lord. My lord, if your lordship thinks that mediation will do, my lord, your lordships can send it to the mediation. I have no objection. I am always try to mediate, my lord. So
Serve them and come.
my lord,
And come. I'll
26. My lord, 23rd is the date fixed in the, my lord, tribunal, my lord,
for what?
for hearing of that, my lord, application, my lord, 5-1 application. A limited period stay, my lord, in that event. Lord, I
Why
shall
should I stay? What is the application that has been filed?
my application is not here, my lord. The 5-1 application notice, my lord, page 52, my lord. I have annex, my lord.
So go and argue there. What is your problem? Why should I stay the proceeding? They have a right.
Yes, yes.
Then?
My lord, since,
What
my
is
lord,
wrong with the proceeding? There is nothing wrong with the proceeding. They have a right. They have initiated the proceeding.
no, my lord, what is I'm asking, my lord, section 4 is, my lord, since the mother having a gas agency, he is not unable to maintain herself. Therefore, she is not coming within the ambit of this, my lord, act, my lord. Lord, I shall serve.
Where is the application? Show me.
Lord, application copy ta hai, sir. Lord, application copy is not with
That
me.
problem you have seen. No, it is not that it is not maintainable. Please see page 51.
Page 51.
Yes.
Yes, my
He
lord.
is the gas agency, but all its profits are being taken away by you.
Lord, that is
Allegation. So if that is the allegation, then that has to be checked. Because merely because you show that on paper she is the owner, and in reality you are enjoying the profits, then in that case she is not having anything to survive. So for this purpose, the tribunal will have to go into and see whether her allegation is correct or wrong.
yes, my lord. I am not saying, my lord.
Therefore,
Tribunal have all, my lord. If an
Therefore, at
application
this
is filed rightly or wrongly, that has to be adjudicated, my
At
lord.
the threshold, it can't be said that the proceeding is not maintainable. This is the allegation. If this allegation is there, then in that case it is maintainable.
In that event, my lord, kindly permit us to produce all the documents, and
But then that is before the tribunal. Go and
the
produce.
tribunal is not, my lord, some direction is required, my lord. If your lordships want to send it to the, my lord, mediation, I don't have any objections, my lord.
Mediation, I cannot send it on my own unless both parties agree. So far as this order is concerned, you have been issued notices. You go and prove before the tribunal that it is not maintainable because they are earning.
My lord, in that event, my lord, kindly permit me to serve for the purpose of mediation, and in the event, my lord, kindly permit me to file.
I will permit you to go and produce all documents there before the tribunal and satisfy the tribunal that it is not maintainable. Why should I rule on the
My lord,
maintenance?
I shall.
Tribunal take the decision.
I and permit me also file in the event if required any application, my lord.
Yes, why not?
Yes.
Uh,
Lord, in this matter. Oh, is it?
In item number 3, my lord, I am for the petitioner, my lord. The subject matter of the petition is, my lord, there was allegation of tampering of evidence, tampering of the meter. The petitioner, before your lordship, used to run one wheat grinding machine. All of a sudden, there was inspection, and allegation is that there is tampering of the meter. And charge was issued against under section 235(1) of the Indian Electricity Act, my lord. They also initiated a criminal proceedings. Time to time, the petitioner paid money. And finally, it was found that he is found not guilty in the petition. He was acquitted, and his bail bond was also discharged. And the judgment of the learned court below, my lord, starts from page 24. And my lord, acquittal parties, if your lordship kindly have a look at. My lord, at page 24, third paragraph, my lord, here it has been said that he is found not guilty and he is acquitted. Number 2, my lord, his bail bond also discharged. Under these circumstances, my respectful submission, subject to your lordship's approval, my lord. Can there be any relief like compensation be given? That is the whole thing, and nothing else. I have served upon respondent number 1 and respondent number 3, my lord. It is subject to lordship's consideration and nothing else, my lord. Point is, he has worked as a public servant. Is he liable to make compensation? My lord, that is the whole thing. Your lordship kindly considers and pass an appropriate order so that petitioner can get relief, my lord. That is the whole thing.
Yes, Mr.
The law is very well settled. It is no more res intriga. So far, it is the two separate proceeding, and lordship kindly appreciate the original consumer before your lordship is, that is
My lord,
Gopal
Gopal,
Barai.
he is dead, my lord.
Petitioner is no consumer, not at all, and there is no privity of contract with the petitioner. Number 1. Number 2, the assessment took place in 2008.
That is a bigger problem.
My lord.
The original consumer is not there. That is a bigger
And
problem.
another main issue, which I am just reluctant to draw your lordship kind attention. My lordship, so far the law is concerned, so far the acquittal does not ipso facto entail them to get the compensation because it's a separate proceeding. No appeal has been preferred against that assessment order. It has been made in 2008. Lordship kindly appreciate. And 2019 acquittal order has been made. Kindly mark the date. Against that order, a writ petition has been taken out. And that writ petition, where this is the order which has been passed and that has been suppressed with deepest respect in this writ petition. And no appeal or no modification order has been application has been taken out in against this order. This has been made for dismiss for want of prosecutions, not for default.
It is
Lordship
for
knows.
default only.
Yes. And on that basis,
Default only.
and on the lordship kindly see the series of time this matter has been taken up, but nobody appears in this matter. And this has not been, there is no whisper in this writ petition itself. And there is a suppression of material fact, lordship. And on that basis, I am just relying upon Dalip Singh case. Lordship knows nobody can pollute the stream of justice. But there must be at least one whisper. Nothing has been made.
Very well.
Lordship knows. I am not going on.
My lord, can a person be harassed for no fault on his part and he has been acquitted? That's why there should be,
That person is
my
not
lord,
there,
there should be sub relief for him.
but that person is not there, sir. That person has left the world.
My
Someone
lord,
else-
yes, this is right, my lord.
Yes, that is why this writ petition.
My lord, subject to your lordship's approval, can anything be done to allow me to file either a supplementary affidavit or by filing affidavit opposition reply, my lord? If your lordship kindly consider this aspect, nothing.
How it is maintainable,
My
lordship?
lord, heaven will not
Why
fall.
it cannot be, lordship?
My
I
lord-
objecting to that.
My lord, let them
I
say.
can grant you leave to make a representation before the authorities. They will consider if you have any case.
Your lordship is granting me leave so that I can take appropriate steps.
File a representation before them.
My lord, much obliged, my lord.
But can it be done subject to your lordship? I know that is a sympathetical issue, but there is no privity of contract. Lordship, kindly appreciate.
I will provide that. That will not
Lordship,
be a mandate.
I deeply oblige.
unwind. My lord, it has not been affirmed, my lord. We have served, but it has affirmed. That is the whole difficulty.
Can I appeal on behalf of the petitioner? At the instance of the private respondent, the petitioner is out of electricity since December 2025, my lord, at the instance of the private respondent. And
Who is the private respondent?
For the private.
Yes, why are you not allowing her to
Let him complete his.
I appear on behalf of
And let him tell the truth before
my
Lordship.
lord.
there's a civil suit pending, my lord. There's an order, but I am
My
in.
lord, I appear, my lord.
Yes, where are you, Mr. Mukherjee?
My lord, there was a matter going on in court number 33, my lord. My lord, that's why I'm appearing online. I'm craving leave of your lordship to appear online. my lord.
In my premises, there were 3 meters. Now, this particular petitioner, my lord, he was allowed to use a single meter by using a sub-meter. He didn't pay. That caused disconnection by the authority. That's the fact. By the authority that was disconnected. Subsequently, he applied for a meter. And my lord, a 4th meter that has been installed.
But the 3rd meter, which was disconnected by the authority,
That has not
was
yet
in-
been restored.
was in her name or your name?
Name of my grandfather,
So that is
which
between-
he was using.
that
well,
is no ground.
No.
That is between.
I didn't say anything.
If you feel that there are certain dues which she owes to you, I mean, the
Well,
petitioner
he
owes
had
to
been
you.
using from that meter only.
Very well. Do you charge them? You
let him
file a civil suit.
now.
Get
Now,
recovery-
but
get
let me
recovery
let me
from-
clarify.
for
Let
that
me
their
let me
right to
clarify.
take electricity
Now, my lord,
can't be
on
complained.
his prayer, a 4th meter that has been installed. Now, in the meter board, there are 4 meters. Main switch is 3. Now, the authority, my lord, for technical glitch, I don't know what they did. The 4th meter connection they have given through the 3rd meter
Whatever,
switchboard.
hear the
So let them
authority.
clarify.
That objection is not.
We are not
My lord,
objecting.
my instruction is very specific, my lord. My lord, we have not disconnected the line, my lord. My lord, there are internal problems, my lord. We have not disconnected the line. Supply from our end is live.
And she is enjoying her own meter.
Yes, my lord, my specific
You have a
instruction
meter in
is
your
that the
name.
supply is live.
You have a meter in
I
your
have a
name.
connection in my name, my lord.
They say that the supply is live at their end. The problem is somewhere at your end.
My lord,
Their supply is live.
there's a loop, my lord.
My
That
lord,
has
they can check the line by the
If you
help
bring-
of the
photograph, my lord, which is at page number 9.
No, but CSC says on record that they have not disconnected. If your landlord or somebody else has disconnected, you have to sort it out with them, get it done by your electrician. It is his categoric submission that they have not done it.
But as far as my instructions are concerned, my lord, yesterday I got that information that they have carried on inspection in that premises.
Very well. So that is why he's saying so. After instruction only, he might have been said so that it is live at their end. That is what he said.
Last evening, there was inspection. I do admit that. What they found. they- No, no, no.
I have been categorically indicates that the connection has been disconnected by the private party.
That I have already submitted.
But if
for
the
your-
private parties disconnect their
No, my lord, I have applied, I have requested the distribution licensee for reconnection, but they have.
if
not
they
acted up-
disconnect,
My lord, it is live from our part. We have not
wait,
disconnected.
Mr. Mukherjee, please wait. Their liability will only be till the main switch, not beyond that. Now, once there is a disconnection beyond that, that is your liability. You have to get it reconnected. They won't. Their duty ends there. They will connect the meter with the main switch and then that's all. After the main switch, if something happens, you have to get it reconnected. That is the law. You get it reconnected. I'll pass that order.
Place the regulation.
My lord, may I place the judgment of Abhimanyu Majumdar, my lord?
Yes, on what ground? If there is an internal dispute, if CSC has
It
not
is
disconnected,
internal dispute.
they have to disconnect.
Yes, your lord.
They have not disconnected. That is their submission. If they haven't
It is a
disconnected,
settled proposition of a property. Just a second, my lord.
settled possession. Yes, that is. They don't dispute that you have a right. They could have been directed to reconnect if they had disconnected.
Yes, your lord.
Try to understand. Their liability is up to a certain point. Suppose somebody goes in your room and disconnects the light. For that, you cannot hold CSC responsible. They have to see whether your meter point is active or not. At that point, if there is electricity that is live, their duty ends, because their duty is to supply. Their duty is not to take the supply to your premises. You have to connect it with the wires. If somebody does that in between, then it will be absolutely impossible for them. So the statute has carved a duty up to a certain point.
Yes, sir.
Beyond that, they don't have jurisdiction.
7.2,
They cannot
my lord,
enter.
at the top.
Yes. It's consumer's installation, your installation. There are two installations. One is the licensee's, another is yours. Got it?
My lord, this bundle can be kept with your lordship.
Thank you. I
Lordship's
needed this
reference.
till such time that I have
My
the
lord.
determination.
Lord, it is with the index.
Very well. लिखे नहीं. Come back in 5 minutes.
No, 5.
Sorry. 5.
I framed for not today, madam.
Not today.
Okay.
My lord, I beg to appear for the petitioner.
Yes.
My lord, petitioner is a owner of a landed property. Now, the peculiar predicament is that the bank seeks to enforce security interest in respect of that landed property. I am neither the borrower, neither I am the guarantor, nor am the guarantor, nor any way connected thereto. Now, what it appears subsequently is that the vendor from whom I purchased, he might have secured a loan with the bank. Now, I have requested the bank to provide me the details because otherwise, if I don't get the details, my lord, I cannot move the appropriate forum, which is the DRT. Now, bank is not providing me with the
Why are you
information.
not providing him the
No,
details?
my lord.
the matter has been settled, bank is not going to take any action against him.
If that is recorded in the order, I have no difficulty.
Give me something to put it on record.
my lord, I have oral instructions from the bank.
No, oral instructions will not do. That creates difficulty. You get something in writing, give a copy to him. I will take it on record.
My lord, I'll do so the next day, my lord.
लिखे नहीं.
Gentlemen, I am for the petition. In an earlier occasion, your lordships directed me to serve with
Now there is a change of panel. You have to serve again. लिखे नहीं. लिखे नहीं. None appears for the petitioner. No accommodation is prayed for. As you also did not appear.
as a senior is out of station for his as a serious person. Senior is out of station for the purpose রথযাত্রা
লিখে নিন। not today করে দিন।
not to
For dismissal এ থাকবে আবার। Not today, next.
much.
It will appear under the same heading. Next. ওই same order. Dismiss for defaulted same order টা লিখে নিন। 17th এ not appeared for dismissal, dismiss for default. ওই পুরো প্যারাগ্রাফটা লিখবেন। Next. Same order, dismiss for default.
I'm for the petitioner, my lord. My lord, as per the RTI reply, the petitioner, as per the RTI application, my lord, the petitioner got the reply from the SBI, my lord.
Last day, Mr. Samim was.
My lord, the
was
petition,
blasting.
my lord, the petitioner got the original OMR, my lord. For that, my lord, for that,
The information he was
my,
vocal on that.
my lord, for that. My lord, at that time, we don't have that information, my lord.
For that reason, he is not here today.
So I'm disposing this off.
My lord, kindly dispose that matter, my lord.
None appears for the petitioner. No accommodation is prayed for. The petitioner remained unrepresented.
But I am for the petitioner, my lord.
But I am for the respondent.
It was a loan against property. Bank has given an offer to pay the outstanding installments, my lord. That the petitioner has paid, my lord, and bank has not stopped proceeding under SURFACE Act. But only one order of magistrate is there, my lord. My lord, if that is set aside, my purpose will be served.
Why magistrate's order will be set as a
My lord, magistrate directed the police.
Challenged.
That I have also challenged before the DRT, my lord.
Then why have you
Then
come
I will
here?
proceed. It may be disposed of us.
This writ petition assails a
For the petitioner, your lordship, this matter is specially assigned before your lordship.
Yes.
The only one thing, a direction is need to be passed by your lordship for serving a copy upon the state, your lordship. Without a quarter of this honorable court, they are not.
Also nobody
Last by hearing was take place and your lordship, the copy was served upon the state on the earlier state panel. Now the new panel has to be served.
None appears for the state respondents. Full stop. Since there has been a change in the state panel, comma. Assign matters wherever it is.
Deeply obliged.
It will be after the fresh matters. 14. Next 7. লিখে নিন। হ্যাঁ, ফার্স্ট হাউস আমরা আসছি।
Lordship, I am the petitioner. I am paying for not today only, my lord.
Why?
Suddenly matter was come, my lord.
Suddenly? Assigned matters always comes up on Fridays. Why suddenly?
Right, my lord. No.
Liखे
They
नहीं?
are the
Only thing
petition-
here, the state would be required to be served, I think, once again after the change
Kindly,
of guard, because,
direction
my
by
lord,
sir-
because, my lord, the issue pertains to demarcation. So state is really the
File
answering
का
response.
None appears for the state respondents, full stop. The petitioner shall serve a copy of the writ petition along with notice on the state respondents as well as the
If it may please my lords, I am appearing for the petitioner. This is an income tax matter which has been specially assigned before my lord. We are challenging the reopening proceedings for assessment year 18-19. The pleadings are complete and the interim order is expiring in the end of the month. There is just one accommodation that I'm seeking from my lord, is that given the current circumstances, there are certain instructions which I need to take, my lord, from the clients. And given what is going on right now, we may require certain time. So I'm humbly praying before my lord that the interim order may kindly be extended.
लिखे नहीं. None appears for the respondents, full stop. Mr. Gupta, learned advocate appearing for the petitioner, submits that he needs some time to take appropriate instructions and prays for extension of the interim order, that is subsisting till the end of July, 2026. In such view of the matter, list this matter for further consideration on August 7.
My lord, some further time may be required. My lord is aware the current
On
scenario.
August 14, 2026, full stop. In the meantime, the petitioner shall serve a notice on the respondents intimating them about the returnable date.
Insofar as the interim order is concerned, that is expiring.
अच्छा, लिखे नहीं.
The interim order is
Interim order granted earlier shall continue till 21st August 2026.
Indeed. I am extremely grateful to my lord for accommodating me.
Grateful, Your Lordship.
ঝুনঝুনওয়ালার নামটা রেকর্ড করে দিন. যেখানে লিখেছেন মিস্টার ঝুনঝুনওয়ালা and Mr. Gupta.
I'm grateful, Your Lordship. But if the interim order could be made till 31st, my lord, it will give us till the end of the month, my lord, in case there are some issues.
So that it can be taken up.
My lord. But just at my end of the month, my lord, it just makes it a little easier, my lord, to.
I've said so that if for any reason I am unable to take it up on 14th, it will come up on 21st
My lord.
again. Yes.
I'm grateful, Your Lordship. I'm grateful.
That I appear on behalf of the petitioner.
State.
State, my lord, what happened, my learned junior, because I told him that as an abundant caution, you file a writ petition, you just serve a copy of the writ petition intimating that the matter will be taken up. And my lord, he had, my lord, served upon the government pleader.
Very well, but they are not there. Serve a notice. I am keeping it next week. I'll take it up.
My lord, may I say only one indulgence? In the next week, I have one personal difficulty for a day. Therefore, my lord, any day excepting the
Can we have it on 1st of August?
Yes, yes, I have no problem.
Saturday.
No. My lord, Saturday week I cannot come. Any day starting from 7. Your lordship had commented that in respect of the amount which they are now receiving, that is a decreased amount from the initial pension, whether at all the court can pass an order for consideration of the claim of compassionate appointment. Now I found a judgment of the Supreme Court where Supreme Court had in very uncertain terms said that grant of pension or any other benefit that cannot be a fetter from the right of consideration of claim for compassionate appointment. This is only one judgment which I got. I will be placing that, and thereafter whatever my lord places. I'm grateful to you.
দিদি লেখা আছে তো দিদি Yes. None appears for either of the parties.
But in this matter, I am appealing for the petitioner, my lord.
For the respondent number 11 and 12, my lord.
But the state needs to be served, I believe. State is not appearing. Reservice needs to
Supplementary list. তাহলে আপনি কি
purchase deed is in question along with other private
Pleadings are
respondents.
complete in this matter, my lord. They have not used any affidavit of opposition, my lord, in this matter. So, my lord, I need to serve the state once again since the panel has been changed. So let me come back once after service.
Just, my lord, may I just change brief, my lord, probably, may I permit it to file the affidavit in opposition?
just now you were vocal that it has been pending since 2024.
Yes, it
Now,
was pending. Yes.
Once he has caught you
Yes.
on the wrong side, saying that you have not filed the pleadings, now you want time to get it exchanged. You are vociferous now that it was till 2024. Huh?
Your Lordship, for the petitioner.
Who is appearing
I'm-
for the opposite party?
I'm petitioner in the person and I'm representing myself. Your Lordship, may I?
Yes, yes, please.
Your Lordship, this is a very narrow issue. If order of High Court has been passed, this Honorable High Court has been passed by Honorable Justice Sampa Sarkar under CO 3964 of 2023. And that order has restricted, that order modified the order of the trial court who permitted the amendment and restricted the amendments and identified the shoot property and the deed which the plaintiff wanted to cancel and restricted the amendment to the scope of the shoot property only and to the scope of the within the scope of the shoot of the identified deed only. That is the issue only. Their amendment are very wide. They have mentioned only date, nothing else.
What are you
So that
aggrieved
that
by?
that is
What
that
are
is
you aggrieved by?
Your
What
Lord,
are you aggrieved by? What is your grievance?
I fear it is my aggrieved. I am aggrieved by the amendments, the present amendments, because these amendments can cloud my deed, which is not the subject matter of the plant, which is not within the scope of the plant. And the shoot property, they are only praying for the shoot property, but the deed is for the whole of the property. It is a big property.
Where is the order?
Justice Sampa Sarkar order? No, it is
The order which
it
is
is in the
impugned.
last of the petition. Impugned order is. It is affecting my property only. I am affected by it only. Although the case has been made not against me, but the ambiguous amendments are worrying me, prejudicing me.
You are challenging the order by which the court accepted the amended written statement after expiry of the time.
Not only that.
That is your challenge.
No, it is not my
Yes.
challenge. When they
That is your,
accepted,
don't say no without looking at your prayers. Please look at your prayers.
Your
and then
Lordship,
say no.
I have not done this application.
Who has
This
done
is
this?
this application has made by defendant number 2 only.
Who are you appearing for?
I am defendant number 4. Yes, and the property is my.
CO 2051
Ah,
is the civil revisional application before this court.
yeah,
2051 has been filed by whom?
by me.
Yes. Now
Defendant number 4.
Come at page 27 of CO 2051. Page 27 of 2051.
Page 27 of 2051.
Yeah.
Your dependent number for petitioner therefore most humbly prays that your lordship may graciously please to pass an order thereby calling for the lower court records and to issue a rule thereby calling upon the opposite parties to show cause as to why an order shall not be passed by this honorable court, thereby setting aside the impugned order dated January 8, 2025.
So January
Passed.
2025 order
Yeah.
was the order by which time was extended and their amended written statement, amended plaint was taken on record.
No, your lordship, they accepted the amended plaint without the necessary changes in the amendment.
The amendment which stood modified by this court, that modification was not introduced in the plaint.
Not implemented. That is the case.
Your case.
Your lordship.
Yes, sir. If there was a modification done, why should that not be incorporated?
Your lordship, can I submit some facts?
Just a moment, not required. This is this small area. We will go into this only. This is revision. We will not go hear it like a suit.
No, I am not going for merit.
That's it. I have understood your case. That is your case. That the modification which was allowed by this court has not been incorporated in the amended plaint. The amended plaint has incorporated within its fold the pre-modified amendments which were sought. That is your case?
That is my case.
Yes. Yes.
My lord, the amendment was allowed. My lord, there are the third round before this honorable court, my lord. In the first round, the amendment was allowed, and the amendment order allowing was challenged before this honorable court. This honorable court remanded the matter back to the trial court for re-hearing. Again, for the second time, the amendment was allowed. For the second time, the matter again came before this honorable court in revision. In revision, this honorable court upheld the amendment, but added 3 lines that says, my lord.
Show us the order of this court.
I am showing, my lord.
It is.
Your lord may look at, my lord, page 224, my lord.
217.
217. Start from 217.
217.
The relevant portion is, my lord.
It is corrected, your lordship. It was.
We have spoken. Let me speak. My lord, the relevant portion is at 224. What my learned friend is agreed, my the other side is agreed, my lord. 224. 224, my lord, if your lordship look at
just a minute.
My lord.
Yes.
Your lordship.
Mr. Pincha.
I am Mr. Pincha.
This page 224, the manner in which you want to read it, the court has read it in a different manner. I am trying to explain what has happened. Even if the entirety of the amendment is incorporated in the amended plaint, that amendment will be restricted only to the scope of the suit and the scheduled property, not beyond that.
Not beyond that.
Therefore, even if they talk about Taj Mahal in the plaint, merely by their talking about Taj Mahal will not be included in the plaint. Even if it is there, the court will not consider it. That is the scope of this order. The order of this court, the predecessor bench, which you are showing.
The amendments they are incorporating are violating the restrictions.
No. The amendments, whatever they may have been, the amendments will be read in the light of this order. It is not that he has to cut out all that portion and file a fresh amended plaint. Because the order of order allowing the amendment has been left untouched. What has been said? Please come to page 224.
Your lordship, if we read the whole of this judgment, then we will understand.
Not required, sir. Please come to page 224. Whole of the judgment we will read, but please come to page 224, which is the operative
plaintiff will have to prove our case at the trial. The amendment,
yes, he will have to prove his case at the trial.
The amendment and the prayer sought to be incorporated shall be restricted. Shall be restricted.
Yes.
The prayer sought to be incorporated.
Yes.
Shall be restricted. But they are incorporating the amendments which are beyond this scope of the suit and the suit of the
incorporate, the court will ignore that. If that is
your lordship, that will not happen there. In the lower courts, the things are very.
If that does not
it
happen,
should be a clear and transparent thing. Your lordship.
Kindly see,
what is the problem if they write the property? If they write the property and if they write the.
That is not the scope of this order. Also, this shows that this says.
Your lordship, kindly read the order.
Page 248 of Miller.
Yes.
My lordship.
Please wait. This we cannot continue. Yes, 248.
My lord, 248, my lord. Here, my lord, kindly give me a second, my lord. Here, my lord, the court, my lord, the first paragraph, the plaintiff have to prove her case at the trial. The amendment and the pair sought for to be incorporated shall be restricted to the scope of the suit and to the scheduled property. But that is what the trial court has said. That is what this honorable court has said, and that is what the law says, my lord. Kindly look at, my lord. Section 32 of the Specific Relief Act.
Your Lordship, I have decisions also.
Section 32, my lord. This is what the CPC
Can I
says.
submit my, Your Lordship?
Order 7, Rule 7, my lord. This is what the CPC says, my lord.
Yes, particulars of the property.
My lord, the court will decide, my lord, and the court is bound to follow what has fallen from this honorable court, my lord. The court is bound to follow.
What is the amendment? Show me that.
Amendment, my lord.
Yes.
Let him show.
Amendment plan should be seen. Your amendment application 86 to 91, Your Lordship. It's vague and ambiguous. 86 to 91. Can I read it, Your Lordship?
No, I will read it. Not required. Yes, now why do you say that this is so expensive, so that I can understand? Page 89, page 88, 89. This is the schedule of amendment.
Yeah, Your Lordship, can I read the whole of the first, second paragraph, that the plaintiff states that in the number 313 in para number.
Please come at page 88. 88.
Yes,
88 is the schedule of amendment.
Yes,
We will come
yes,
to the
Your
point.
Lordship.
Unnecessarily, we will not read everything.
Yeah. First, that in the cause list, the cause title of the plaint after permanent injunction, the word described in the inverted comma is required to be incorporated therein, and for cancellation of the deed of assignment dated 26/11/2012. I have objection to this, that
why?
only date is there, because a separate deed was also executed on that date. That was my deed, so it can be affected by it. 26/11/2012.
Which is the deed of assignment that you are referring to? Which is the deed of assignment?
It is in the plaint they have written, and I identified in the
little fact in the mirror. There is a premises in the Salt Lake consisting of 3 floors. The ground floor is occupied by the defendant, my lord. And, my lord, the first floor is occupied by some other person. Second floor is occupied by me. My lord, all those flats, my lord, the landlord entered into the deed of assignment with the tenants. Ultimately, my lord, my learned friend on the other side, my lord, he purchased the whole building, including our shares. My lord. So we filed, my lord, the suit for a specific performance of the contract, that is the deed of assignment, which was executed by the landlord with us. Here, my lord, that suit was there, but there should have been a prayer for cancellation of the assignment of lease, which was executed in favor of my learned friend.
By the landlord.
By the landlord.
So but you have prayed for cancellation of the deed. So if you have asked for specific performance, how can you seek cancellation of the same deed?
My lord, unless the sale deed is cancelled, my lord.
No, you are seeking cancellation of deed of assignment.
My lord,
And you said that you wanted specific performance of the deed of assignment.
my lord, may I clear, my lord? My lord, there were 3 deed of assignments which were not registered, because at that time, sale of the property in Salt Lake was not allowed. So that was unregistered. After, my lord, the government opened the registration of the property in Salt Lake. My learned friend got the permission from the government, urban department, and the landlord, both of them executed a deed of assignment. What I am talking about, my lord, that is a deed of assignment executed in the favor of my learned friend.
So why don't you clarify that? You clarify that here in the amendment, because if you keep it vague, cancellation of deed of assignment dated November 26, 2012, he is right in saying that it will mean everything.
No,
What? So
no.
you have to be specific. You
My-
say
my-
deed of assignment executed by whom, in favor of whom. That will make things clear. Where is the problem?
My lord, deed of assignment, my lord, the deed of assignment, my lord, the deed of assignment is the only deed registered deed. There
You
is
say
no other
deed
deed.
of- then you say the registered deed of assignment, so that it is clear that this is what you want. It makes things clearer.
My lord, that would be, my lord, that would be apparent from the other pleadings in the
But what is the problem in inserting it here? It will create, it will obviate many problems. His problem will also be solved. You will not be standing at any kind of risk. That will solve your problem also if he clarifies this.
Your Lordship, in fact, what happens? The plaintiff has challenged a private deed. Executed.
That is different,
Your,
sir.
Your Lordship.
Their amendment has not been scuttled. Please understand the court before pouncing with a reply. Please have some patience, because this is not the proper way. That is why you should either engage an advocate or you should follow the etiquette. When the court speaks, you also start speaking. That is not the way.
No, Your Lordship.
Yes. Now here, for cancellation of deed of assignment dated 26 November 2012, he is entitled to make a prayer. Now you say that this prayer is omnibus. It includes it within its folds such other deeds, cancellation whereof he may not be entitled to ask. Whether he is entitled to ask or not is a different question. Going by the order passed by this court, it should be restricted to the suit property. Now, if the deed of assignment, cancellation whereof he seeks, is related to the suit property, he is entitled to seek cancellation thereof.
Lordship, here the things comes. The Honorable Court has identified the deed and identified the suit property. Can I read the?
Show me.
Yeah, that is the main thing.
Show me. Main thing. Show me.
224. That is the main thing, Your Lordship.
Show.
It is in page number 223, Your Lordship. I'm starting from thus. Now the court has inferred. Thus, the suit was with regard to an alleged assignment in respect of a self-contained flat at the second floor of the building containing an area of 2,150 square feet together with all electrical and sanitary fittings and fixtures, etc., and parking space in the ground floor. In paragraph 13 and 14 of the said plaint, it has been categorically mentioned that the plaintiff came to know about the deed of assignment dated November 26, 2012, entered into between the defendant number 1, the defendant number 2. Your Lordship was pleased to cut the and the government of West Bengal, deleted. Defendant number 2, by way of an amendment, this deed of assignment was sought to be challenged. A prayer for cancellation was made. It is identified by a deed executed between defendant number 1 and defendant
Where is
number
the
2.
problem then? I don't.
So if they write it, then there is no problem. If they write in the amendment that it is executed between defendant number 1 and defendant number 2, then I have no problem, sir.
The court clarifies that. I will clarify it in the order that the prayer for cancellation of deed of assignment dated 26/11/2012 will mean the deed of assignment which has been referred to in paragraphs 13 and 14 of the plaint. That is the deed.
That is the deed.
That creates that solves the
yes,
problem.
and the suit property is also identified.
So that should solve
that should
the
be
problem.
then no problem. If that is written in the.
I have no objection, my lord.
That is what is written in the order also.
Yes,
Then
I
that
have
is
no
already on record, my lord.
But
Yes,
Your lordship
but your
want to play-
lordship, I think the plan should be transparent and.
No. Unnecessarily, this will create problems. He will file another amendment application, another amended plate. The prayer is simple. The prayer has to be read in the light of the pleadings. That is settled law. Mr. Mukherjee will tell you.
Your lordship.
The prayer is not to be read on a standalone basis.
Yes.
That you will make some pleadings, and then in the prayer I will say that therefore it should be declared that I am the owner of Victoria Memorial. That cannot be the prayer. So if I have made a prayer for ownership of a building, the building ownership whereof is prayed for in the prayer must be relatable to the pleadings that have been made in the plaint.
Made in the plaint, and that is identified by the.
I will attach this paragraph of the order, with paragraph 13 and 14 of the plaint, and relate it to the prayer made.
And
That should solve the
thus the
problem.
suit was with regard to the LS assignment in respect of a self-content.
My lord, if the deed is identified, my lord, by giving the number, serial number, volume number, I will give it, my lord. That is much better for him.
Yes.
Why there is no number in the plaint? They have only mentioned it.
Much better, my lord.
There is
Volume
what
number,
is in
book
the
number,
plaint.
I will give
Within the scope of the plaint, they can
See,
write.
if it is there in the scope of the plaint, he can do it. If it is not there in the scope of the plaint, he can seek amendment to clarify it. That also can be done. But it is for him to do. For the moment, this is what appears. I will clarify that.
Yeah, and the
your lordship, please, my lord. But my lord, it is every time, my lord, this kind of dispute, my lord, I will give the book number, volume number, pages, and where it is registered.
How?
That you can pray for
Another
a
amendment
separate amendment by way of clarification that you can bring. But at this, I will not enlarge the scope.
But I am not praying for enlargement, my lord. I am not praying for
I am just clarifying that this is what it means. It has been recorded in the earlier order also. There should be no problem with that.
And they have not challenged this order also.
No, they are not required to, because the prayer of amendment was not refused. The prayer of amendment was read in a particular manner. That is what I am clarifying.
Your lordship, now the second amendment I want to come. Your lordship, I am very sorry if I have done anything.
Yes, no. What is the second amendment?
Second amendment I am coming, your
Yes,
lordship.
yes.
My lord, here is one difficulty, my lord. Here is one difficulty, my lord. The deed of assignment, my lord, was executed, my lord, by Gautam Kumar Pincha.
Sir, the court has read it in a particular way. Kindly come to the order passed by this.
I have seen, my lord. What your lordship has fallen from lordship, my lord?
I'm just explaining that only. I'm not going to add anything to it. The court has said this. Show me paragraph 13, 14 of the plaint.
13, 14. I am showing.
Plaint, it is, yeah. No.
The plaint.
I mean, that is from
65
85
to
page
85.
85.
Can 65 to 80.
Page 85.
Yes, 65 to 80.
My lord, the
it
prayer
starts
is, my lord,
13, it is.
65, my lord. Beginning is 65. my lord.
65. I wanted
13,
to see the
paragraph number 13.
paragraph 13, 14.
79, sir. 79, your lordship.
79.
My lord.
13.
Can I read, your lordship?
Not required. I can read. So it is in respect of paragraph 13 only that the deed has been explained by you.
13 and 14 both are there, your lordship.
Defendant number 1, heir of Monirani Guha, to execute registered deed of assignment.
खाली वही क्लेरिफाई कर रहे हैं जो
Yes.
My lord, the only difficulty here, my lord, the defendant has come before your lordship, my lord, against an order passed on an application under Order 6, Rule 18. That is the scope of the revision.
Correct.
That is the scope of the revision application.
The revisional application scope is to see whether the
whether my amendment is liable to be rejected on the ground.
No. Whether the amended plaint is in terms of the order passed by this court or not. For example, if in the amendment you had prayed for X, Y, and Z, court had allowed X, Y, and Z. There was a challenge thrown. This court says that X, Y, and Z would mean Z, or X, Y, and Z would mean A. Now you file a plaint, amended plaint, introducing X, Y, and Z. But you don't say that it means A, although this court has said. He has challenged that because the plaint is not showing that in so many words. Now this court, is it powerless to express that?
No, my lord.
No.
Sorry, my lord.
I'm just asking.
I don't mean to say, my lord.
No. Is that expression
The only thing is, my lord, what I say, whether the observation of the court has to be incorporated by way of amendment, that is the issue here.
No, observation of the court is not required to be incorporated, but in case there is doubt, clarification may be given that this is what the court wanted to say.
That is always there. That is always there.
Your lordship, it is not observation. It is modification and determination of the court.
I will not call it modification. The order
No,
does not say that.
it is written there that it is modified.
Show me.
Yeah. 224. It is there. Order is modified.
Yes. Order is modified. So therefore, the amendment was modified.
In that event, my lord, kindly permit me. I will incorporate that.
And amended plaint was
That
right before this order and passed.
Let it be in, my lord, for all time to come. I will
Elder
incorporate.
has told
Not to
them.
direct me, I will incorporate. That particular paragraph, I will incorporate in the amendment.
Your lordship,
yes,
I can tell. They wanted to. I have to show the order of the trial.
Very well. Then I am doing this. I am sending this matter back before the learned trial court. He will get liberty.
Your lordship, it is
to incorporate.
He will get liberty. He will get liberty to incorporate the amendments in terms of the order passed by this court, and he will now incorporate it in terms of the order dated 3rd of January 2024 passed by this court.
My lord, kindly give me 14 days time, I will incorporate.
He will incorporate.
The matter ends, that is grievance.
Your lordship,
that should be sufficient for you.
ট্রায়াল কোর্টে এইটার ইয়েতে নতুন করে অ্যামেন্ডেড প্ল্যান জমা
He will file a fresh amended plaint in terms of this order.
I will incorporate that particular paragraph.
In terms of this order, he will incorporate.
yes, that prayer has been made by us also in the trial court, but it was not entertained there.
You incorporate the amendments in terms of the modified, in terms of the amendments.
I kindly clarify, my lord. His grievance is that paragraph,
your lordship,
that
one by one.
His grievance is that this particular paragraph, that the plaintiff have to prove the case at the time of amendment and the prayer sought to be incorporated shall be restricted to the scope of the suit and to the scheduled property. I will incorporate this.
No, this is the observation of the court.
Yes.
Your amendment will be restricted to the suit property, and your prayer will be restricted to the suit property.
My lord, I will incorporate.
So therefore, the deed of assignment which you are challenging must be a deed of assignment which relates to the suit property.
My lord,
that is all.
I will do it.
That should suffice.
My lord.
And now this, your lordship, I think We wanted also that thing that the identified property should be mentioned.
That
and
this the
identified
deed of you will clarify that the deed of assignment relating to the suit property.
which is mentioned in the plan should be there.
They will say it relating to the suit property. That is what the
My lord, I will say
deed of
Related to
assignment
the suit
relating to the
property,
suit property.
there are 2-3 deeds related to the suit property. Then they are wanting a specific deed to be cancelled. That is
So they will
executed
they will
between
introduce
defendant
the
number one.
then they will introduce the particulars of the deed relating to the suit
Your
property.
lordship, particulars of the deed, if matches with.
Pincha, you cannot have it both the ways.
No.
You will not allow them to incorporate the particulars. If they incorporate the particulars, then you say that that is not the scope of amendment. If they don't incorporate, then you say that the deed of assignment is omnibus. Take one stand.
Your lordship, kindly listen me 1 minute.
I have been listening to you for quite some
They-
time.
The plaintiff has challenged a deed which has been incorporated by defendant number one and defendant number two, not the government of West Bengal. It is a private
government of West Bengal or not government of West Bengal.
it is
not
a
concern.
No,
The
your
court has
lordship,
recorded.
it is a
The court
private
has
deed.
recorded that the amendment will relate to the suit property. He will incorporate that this deed of assignment will relate to the suit property.
Within the scope of the this identified, it has been duly identified by the honorable court.
Identified, not identified, whatever it is.
Your
if it
lordship,
is in
the
relation
high
to
court,
suit property,
the honorable high court has identified the property and within the scope of the suit and restricted the amendment to the scope of the suit only, not beyond the scope of the suit. If it is beyond the scope of the suit, then they cannot.
Your lordship,
If it is within the,
can you make your arguments again on next Friday?
your lordship, then second amendment is also.
Friday.
Your lordship.
Heard Mr. Pinch. Be taken on record if it is exceeding 2 pages.
It is only to assist the court.
No.
না বলছেন 2 পাতার বেশি হলে
Give me on the next occasion when you come.
Next.
If it is more than 2 pages, I will not take.
Okay, your lordship.
My lord, may I confirm? My lord, item number 18 of the appellate side matter, my lord. My lord, it has been kept on 14th of August. However, my lord, in the matter, learned senior advocate Mr. J.P. Kisan is meeting the matter. My lord, is available on such day. My lord, if the matter may be kept on 24th of August.
24th, it can't be. It has to be a Friday.
Then,
Has to be a Friday. On that day, if he is unavailable, make prayer. I'll again adjourn.
না আমার বলার নেই জজ সাহেব তুমি আমাকে যেদিকে খুশি না
What?
I am the petitioner.
Acha,
That matter.
yes, I understand. He will not be able to conclude today.
Yes.
In the meantime, you please serve the state. There has been a change in the
The state has been
panel.
served.
No,
Service
that was served earlier,
earlier.
not after the change of
After
panel.
the change of government, you put it.
Government has been done. Mr. Das Trivedi appeared, then we.
Mr. Trivedi last no.
Mr. Trivedi had said.
Yes, yes. Now the
Sarvin,
present
it
government.
is not that he appeared on your service.
Yes, yes, yes.
It was on my indication that he.
Yes.
But then the panel had not been prepared then. For
So,
the purpose of completion. please
No,
serve so
we'll
that,
serve. We'll serve. We'll serve. No. We have served. This is falling from the code. The government has changed. New panel has formed. We have to serve again. No. We'll come back.
Yes, Mr. Banerjee.
Should I start today or should we come?
Why not? Because
Because I won't be able to con.
Yes, I know. So start. At least we shall be able to proceed something.
Wait.
Mr. Bhattacharya is the bank.
Where is Mr. Basu? He's not there.
He's coming.
Better sense has prevailed upon Mr. Bashu Miller not to do these types of matters. Need not look at the records, Miller. Let us, Miller, just.
Which one are we?
Kindly take, Miller, the bank's rate petition.
Punjab National Bank আছে আলাদা করছেন না কেন একসঙ্গে আমাকে সব দিয়ে দিলে তো আমি কিছু বুঝতে পারি না
Miller, bank's one is.
দিয়ে দিলে আমাকে আলাদা আলাদা করে দিতে
Record aside, Miller, just for a brisk Miller recapitulation, my lord is now Miller seized of two rate petitions. One is by bank, where Miller Bank apparently Miller has made an innocuous prayer for Miller expeditious disposal of a section 14 Miller application. And Miller, the other one is by the purchaser. Purchaser says, Miller, enough is enough. Give my money back because bank is not in a position, Miller, to make over physical possession of the property. Miller, there are previous orders.
Mr. Banerjee, why is your appeal not being heard by the DRAT?
Oh, Kobe next day, sir?
They have not
But I'll just indicate the next. But I'll indicate the next.
Why are you not taking steps for hearing of your appeal?
No, steps are.
They have not deposited the money. They have not deposited the money.
Kindly record this statement, Miller. If he has instruction, kindly record this statement. Miller, if he is taking the responsibility of making this statement in court, kindly record
You are sure you have deposited?
Miller, the deposit, Miller, mostly has been made. Miller, a little amount is left out.
That
Which,
means
yes, no, he's not. He's saying, Miller, deposit has not been made.
So if you have
3.5 crore, Miller, has been deposited.
So what? If you have to deposit,
You have to deposit more than 14 crores.
amount
Miller,
which
if you lack is
but that means that his deposit is not yet done in terms of statute.
correct. And Miller, extension has been given, granted. They have not preferred Miller any Miller revisional application from those orders. So Miller, they have accepted it. And Miller, in any case, that is. Miller,
No, that has a bearing because this proceeding is being extended only because of the pendency of the appeal. If the appeal is disposed of one way or the other, you get a clarity on the matter.
May not be Miller. I tell your lordship, Miller, why?
Last order which I have.
DRAT order.
This is the order of the DRA.
The 10th of June.
Thereafter, if any
10th of June, order of dismissal will be passed. What happened thereafter? What happened thereafter? We are on
I have
July.
filed an. I understood, my lord. I have filed an application for reducing that from 30% to 25% because I have taken a loan from 4 crore 50 lakhs.
bank has claimed 14 crores without giving any single documents to the court. They have verbally said my claim is 14 crores. On the basis of that, my lord, order passed to deposit 30% of the claim amount. So I have already deposited 25% of the claim amount and requested with an application to reduce that amount. And court has extended the time you deposit that money. I am not allowing you. Am I allowing you to pay that amount within stipulated time, my lord? I am not equipped with that last order. So that appeal is pending, and my lord, we are on depositing money.
Application is also pending.
That 30% to 25% not made, but 30% I have required.
আমার পয়নি অ্যাপ্লিকেশন করে ডিআরইতে রিডিউস করার জন্য টাকা।
Milord, the outcome of DRT proceeding may not have a bearing here. Milord, I just indicate, Milord, why in one line. Today, my lord is, Milord, possibly, Milord, looking into, Milord, the possibility of, Milord, passing an order directing the magistrate, Milord, to take up the section 14 application. Milord, before, Milord, doing so, Milord, on the last occasion, Milord, I, Milord, advance my argument. My lord has to at least prima facie satisfy that there is a section 14. Milord, as envisaged by law.
That can be decided by the DM also, whether there is a section 14 or not. If everything High Court decides, then what will the DM do? DM is having some powers, though ministerial, even if that ministerial work
No,
is not done.
nowadays, Milord, DM has the power to look into the veracity of the statements also.
That was always there. Looking into the veracity is also, it's not adjudication. It is ministerial in that sense. So that is also not required to be done by the High Court. If there is no application, DM is supposed to say there is no application.
There's one more
If
point.
there is application, DM is supposed to say on this application, this order can be passed. He cannot sit tight for years together and say that no, I will not pass any order. When the High Court directs, I will pass an order. That can't be the attitude.
Provided, Milord, there is one section 14 application.
If there are many, he has to say on many, whatever it is.
Many before many persons.
Whatever. The person before whom the application is there, he is at least, maybe there are hundreds of civil revisional applications before me, all on the same point. When one comes before me, I am to take a call on that. I cannot keep all of them pending. If it
I
is
follow.
pending-
DM can say, since there is a previous application for another authority, I can't take it up.
Yes, at least say so. You can't just keep on it.
I follow. Now, Milord, so far as the bank's writ petition is concerned, Milord, I was just trying to show, Milord, if someone comes in before a writ court, deliberately making, Milord, one after another false statement. Milord, I was, Milord, posing this question to myself, whether, Milord, this kind of a petitioner, and that also being, Milord, a nationalized bank, Milord, can be held to be entitled to any sort of relief. Milord, you have learnt it from your lordships that, Milord, অনেকবার আমি জজ সাহেবের সাথে মামলা করার সুযোগ অনেকবার পেয়েছি সাথে এগেইনস্টে that Milord, if Milord writ petition is full of Milord false statements made on oath, Milord, that petition should be rejected, Milord, at the very threshold without, Milord, showing any kind of, Milord, indulgence to the petitioner. Here, Milord, I will show one by one, Milord, how many false statements have deliberately been made. Milord, had there been one, Milord, typographical error, I could have, Milord, understood. Milord, there are intentional suppressions.
In the writ petition?
Yes. And, Milord, there are false statements as well. Not only in the writ petition, Milord, in the documents, Milord, which are relied upon in the writ petition also, which form, Milord, integral parts of the writ petition. And, Milord, the statements made in the body of the petition, some statements are, Milord, belied by, Milord, statements contained in the documents. Some statements in the documents are belied by some other statements in the documents. So, Milord, if that be so, possibly, Milord, the equity jurisdiction, Milord, the just, Milord, good conscience jurisdiction is not, Milord, available to, Milord, my learned senior friend. Milord, may I just show one by one? Kindly, Milord, turn to first, Milord, paragraph 18 at page 10 and paragraph 12 at page 8. Kindly take page 8 first.
Page 8.
Huh?
Page 8, para 12.
Yes, my lord, this is their bone of contention. That, my lord, the blame is on this court. Because of pendency of these writ petitions, my lord, the bank's hands are tied. My lord, there is a reiteration of this statement in, my lord, paragraph 18 at page 10.
Page 18.
Yes.
Paragraph 18 at page 10.
Yes, my lord. Says, my lord, it's because of the act of the court they are suffering. They should not suffer for the act of the court. They mean to say, my lord, this honorable court. Now, my lord, kindly turn to page 4, paragraph 2.
Yes.
My lord, they are referring to a sanction letter of 16th March 2020.
Yes.
Kindly, my lord, turn to page 21.
Page 21.
Yes, my lord. My lord, kindly have a look at third line, paragraph 5.
Yes.
Kindly see, my lord, the date of sanction. Then kindly turn to which, my lord, does not tally with the statement made. Then, my lord, let us take it as a typographical error. Then kindly turn to page 44.
Page 44.
Yes, my lord. My lord, this is what is placed, my lord, before the magistrate. My lord, the application starts at page 41, which is, my lord, second in point of time. The first one was before, my lord, CJM. This is before district magistrate. Oh, I'm sorry, my lord, I stand corrected. My lord, my learned friend is correct. This was first in point of time DM. Then, my lord,
44.
41. 41 it starts, 44 is continuation of that. Kindly, my lord, have a look at 41 once, my lord, before whom this application was placed. This is before DM. Later on, my lord, there was an application for the same relief pertaining to the same property before CJM. So once, my lord, I file a second application under section 14, by necessary implication, I give up, my lord.
Second application?
My lord, that we have indicated in our affidavit. I will take your lordship to the affidavit.
Before, just across this, please take me to that so that I can mark it.
My lord, page 24 of our opposition.
Of your opposition.
To this writ petition.
Yes.
My lord, I'll take your lordship, my lord, to that. Should I now?
Yes, yes, so
Yeah,
that it will be easier for me to keep my
yes.
markings.
Our opposition.
Page
24.
Page 24. Page 20.
My lord has kindly got it?
Yes, yes, I have got it. Yes, दीदी आपका flag देवे. Yes.
Lord, kindly have a look at, my lord, the case number at page 24. It's of 2025.
Yes.
And kindly, my lord, read along with this, my lord, page 24 of the opposition, page 41 of the petition. My lord will kindly get the date of page 41 application at the foot of it on the left hand side.
2022.
So, my lord, this is later in point of time. The moment, my lord, I file a second application, my lord, I try and impress upon your lordship that, my lord, I necessarily, my lord, abandon the first one, for which, my lord, they have come up before your lordship. Today, they want an order from your lordship that DM should pass an order. My lord, after having abandoned this application. Well, that's, my lord, that would be my argument before your lordship. They can't maintain two, my lord, at the same time. Second application, my lord, substitute the first necessarily. And Milord, for reason
Yes.
for reasons Milord best known to my learned friends, clients, Milord, they did not disclose this before your lordship in the writ petition. Milord, a glance at the writ petition would Milord create an impression that Milord, this is the standalone application before the district magistrate, which Milord district magistrate is not taking cognizance of. Completely Milord suppresses Milord filing of the subsequent application. Now Milord kindly turn to page 44 of Milord the writ petition, which Milord I was trying to Milord show to your lordship. So Milord, my lord has Milord found one Milord disparity between Milord the date of sanction. Page 44, Milord, serial number 9 and serial number 10.
Date of sanction, Mr. Banerjee, will not be of much relevance here because there is a default.
So, Milord,
there is no doubt as regards sanction. There is no doubt as regards default.
There is a doubt as regards Milord the loan amount.
Very well, but date of sanction is.
That's why Milord I submitted. Milord, I voluntarily submitted. Let us take it as a Milord typographical error.
So leave that out of the picture.
Very well.
Yes.
Page 44.
44.
Milord, item numbers 9 and 10. 9, Milord, there is a difference between 9 and 10. Milord, the heading of these two items. Amounts in figure and words and date of loan sanctioned by the secured creditor. So, Milord, amount of loan sanctioned 7 crore 50 lakh. Next one is amount and figure etc. of loan taken. So, Milord, amount disbursed. One is Milord sanction, the other one is disbursed. Disbursed, Milord, they say 7.5 crore. Kindly Milord call upon them to show that Milord 7.5 crore has been disbursed. It's Milord 4.5, which my learned friend was Milord just now indicated.
This is there in your affidavit.
Yes.
Page.
Milord, kindly turn to petition edition. Page 82, Milord, of my opposition. No, kindly Milord take paragraph 5 again, which my lord has seen just now. Milord, around 8th, 9th line from the top of paragraph 5, my lord will get the figure. My lord has kindly got the figure?
Yes, sanction rupees 7.5 crores.
7.5 is sanction. Actually disbursed, my lord, is 4.5.
About the middle, a little above the middle.
Correct.
Disbursed 4.5.
Correct. And then Milord kindly.
Yes.
Now, Milord, kindly turn to page 86. Milord, internal page 6 of the DRT order. Milord, paragraphs 24, 25, and 26. They accepted before the learned tribunal. That
86 of your AO.
Yes, Milord, 86 of my opposition.
Yes.
24, 25, 26. They admitted, Milord, upon inquiry from the learned tribunal, that yes, 7.5 crore, I have not availed. I have availed 4.5 crore. Now, after having seen this, Kindly, my lord, turn to page 4 of the writ petition. My lord, I think I should make a table, my lord, which would be, my lord, comprehensive. I will, my lord, come back with a table. I'll supply, my lord, of course, a copy.
Page 4, paragraph 2.
Yes. Kindly see the language. Is the borrower and constituent of the petitioner and had availed a facility of 7.5. From the first breath in the petition, my lord, they are on falsehood. And this is, my lord, he says, to my knowledge. Can you see the affidavit? To his knowledge. And he is from a different branch altogether. Then, my lord, kindly take page 18, my lord, of the writ petition.
1.8.
1.8.
Yes.
My lord, 13.2 is a demand. My lord, the demand should be, my lord, in the form of a notice calling upon someone to pay within 60 days. There can't be any second, my lord, thought about this. Kindly have a look at the notice.
But these are grounds which you will take before the DRT if you challenge the 13.4 proceedings.
My lord, I was
These
just,
these will not be available before even the DM.
my lord, I was just wondering aloud. My lord is sitting, my lord, in writ jurisdiction. My lord, if something shocks my lord's conscience, if, my lord, any preceding fact shocks my lord's conscience, would, my lord, I'm of course asking this, my lord, I'm thinking aloud. My lord, would, my lord, send them back to DM, my lord, for, my lord, hearing or disposal of an application, which, my lord, should be thrown, my lord, into the garbage.
So here also they have asked for only 4.65.
No, I'm not on that even. Kindly have a look at the notice. My lord, 13.2 is a, my lord, sine qua non for 14. No doubt of it. Kindly see, my lord, who was the addressee of the notice. Kindly turn over the page. Kindly come to the next page. My lord, there was no demand upon these individuals. And if, my lord, my memory is not, my lord, fading, possibly my lord was there, my lord, in a matter in where my lord was, my lord, on this side. That, my lord, which, my lord, settled the law that, my lord, unless, my lord, a notice is sent to a borrower calling upon him to pay, my lord, there is no demand raised on him. My lord, just supplying a copy meant for someone else does not, my lord, raise a demand.
The addressee is not the mortgagor.
Yes.
Property
belongs to, my lord, the addressee. But, my lord, 13.2 on all the borrowers. Unless, my lord, it is.
But so far as the enforcement of security interest.
No, my lord, that can't happen. My lord. Oh, property is owned by the individuals. My lord, even a beta case. Even a beta case. Even a beta case. बोलना मैं तुम्हें हमें घाबड़े दिले. My lord, I remember that, my lord, it does not belong to the addressee. Was a little, my lord. Does not belong to the address. So, my lord, again, I'm thinking aloud. My lord, will it, my lord, permit my lord's conscience, my lord, to send a section 14 application for adjudication when there is apparently no 13.2 demand on, my lord, the property owner? Why, my lord, an administrative authority should be, my lord, burdened with an unnecessary exercise?
Yes.
Now, my lord, this is the 13-2 notice which, my lord, they are referring to. Kindly have a look at, my lord, page 5, paragraph 4.
Page 5 of the
The
opposition.
writ petition. My lord, I take the writ petition as Gita, as gospel truth. I am on, my lord, 711. Paragraph 4 refers to this 13-2 notice, and the writ petition does not refer to any other 13-2 notice.
Yes.
Now, my lord, kindly. Now, my lord, kindly turn to the application before DMA. My lord, kindly turn to page 49 now. No, date of 13-2. Oh, I'm sorry, my lord, 45. I'm sorry, my lord, 45.
It's 45.
45. My lord, third item. Serial number 14 rather.
14.
Yes. Kindly see the date of 13-2 now. And kindly tally this with, my lord, their averment and page 70. Now, my lord, kindly turn to. Oh, very well. My lord, my learned friend wants to show, my lord, another portion of the application where the same thing is reiterated. Page 47. My lord, kindly have a look at clause 6, Roman 6, because, my lord, there have to be, my lord, 9-point satisfaction. So these are the 9 points, my lord, indicated in the application on oath. So, my lord, it's their oath versus their oath. Their oath before the magistrate versus their oath before your lordship. Another date, my lord, is indicated. Now, my lord, kindly take page 6, paragraph 7. My lord has possibly never come across, my lord, this kind of a writ petition. Every paragraph tells a different story. Page 6, paragraph 7. This is again, my lord, true to his knowledge. In the course of pendency of the essay, the petitioner bank proceeded to issue a sale notice in September 2022. Kindly turn to page 20. Back to it. My lord has noted that September 2022. Now, my lord, kindly turn to page 20.
Yes.
My lord, third line. Rather, first 3 lines of the order, which is now before DRAT. I know, my lord, all these points I can, my lord, agitate before DRAT, and we are agitating. But the question is whether this kind of a section 14, my lord, the learned magistrate should be unnecessarily burdened with. And in any event, my lord, by affirming this kind of a writ petition, can he claim any relief from a writ court where every statement is wrong and belied by record? Then kindly take, my lord, paragraph 5 of the writ petition at page 5.
Yes.
Kindly see, my lord. So 13.2 does not tally. My lord, the authority before whom section 14 does not tally. Sale notice does not tally. My lord, borrowers are not put on notice on demand. Then, my lord, possession notice. Kindly have a look at the date of the possession. Firstly, my lord, this could not have been because, my lord, going by section 14 application, the 13.2 is of 2021. So, my lord, 2015 could not have been, my lord, a possession notice. Now, my lord, page 45.
Page 45.
Yes. 45, my lord, of the petition, serial number 20, 19 and 20.
Yes.
Now, my lord, kindly take page 21 and 22, my lord, of the writ petition.
21.
Yes, ma'am. Paragraph 5, my lord has already seen this paragraph twice for two different reasons. Now for the third reason, my lord, I am showing this. My lord, somewhere towards the middle of paragraph 5, a little down below, towards the middle, my lord will kindly find, my lord, a sentence starting with being aggrieved with the measures. Kindly, my lord, may I read this, my lord, sentence aloud. Being aggrieved with the measures taken by the respondent bank under Securitization Act, essay number such and such was filed by the applicants, which resulted in disposal being infructuous due to undertaking of the respondent bank that it will not proceed under Surface Act, rather it has obtained suitable order in OA, but later on again 13.2 notice was issued. My lord, this was the undertaking. Quoted order. Quoted order. My lord, first page, last three lines. The interparagraph. Rather, my lord, kindly read from however. Second paragraph, the fifth line from the top, however. My lord, this is a statutory right, not a fundamental right which cannot be given up. Transcourt says, my lord, can proceed parallelly, but he has a right to give it up. This is a right conferred by law. He has a right to give it up. He has given it up.
This order does not form part of your pleadings.
I'm sorry, my lord?
This order does not form part of your pleadings.
No. My lord, this order is reflected in the order which is, my lord, annexed to the writ petition.
Yes.
Now, my lord, page 30 of the writ petition.
30.
30.
Yes.
My lord, paragraph 46, admitted position, property is fully tenanted. Same thing in paragraph 32.
Paragraph
32. Page 32, my lord. I'm sorry. My lord, it says that, my lord, the fourth floor, 50% of the fourth floor and in the entire fifth floor is unauthorized construction.
32,
So,
which paragraph?
oh, I'm sorry. My lord has seen, my lord, page 30, fully tenanted. Now kindly turn to page 32, running
paragraph?
page, paragraph, my lord, 57. Bank's valuation report says, can you have a look at this paragraph? May we read it aloud? The valuation report has been filed by the bank along with supplementary affidavit. From perusal of the valuation report, it transpires that under column 5, description of the property has been given, and as per details, the land area is such and such with one G+5 storied building. But it is also mentioned in the report that 50% of the 4th floor and the entire 5th floor was constructed without sanction plan, and as such, it has not been considered under column E specification, etc. Then after deducting 20% tenancy, Milord, the valuation is done. Milord, why I am showing this to your lordship? So, Milord, as per valuation, 50% of the 4th floor and the entire 5th floor is not mortgaged. Unauthorized, they are not even going to sell it because valuation report does not cover it. Section 14 application, Milord, comprises of the entire building. On one hand, he says it's not mortgage, can't be sold, this is unauthorized. By filing section 14, he wants to oust Milord everyone, even from the 4th floor and from the 5th floor. Kindly have a look at Milord the section 14 application, property details now. Kindly turn to page 44.
Just a moment, Mr. Kant.
My lord, is that page 44? My lord, kindly take serial number 11. He is not excluding my lord 4th and 5th floor.
Page?
My lord, 44. Serial number 11, schedule of property before TM. In the application, Milord, which is now abandoned. G+5. That's the property they want to take possession of. Can't have any business, Milord, with 4th and 50% of 4th and Milord 5th floor. And then kindly turn over the page. Kindly turn over the page. Milord, serial number 22. My lord has just now seen that the entire property is tenanted as per the bank's valuer and as per the bank's own admission before DAT. And this is what they are saying before the magistrate. Then, Milord, page 34.
And Mr. Banerjee, how long will you take?
Milord, I think, Milord, I should make a comprehensive one-page table and come back to your lordship instead of troubling your lordship, Milord, moving hither and thither every time. Milord, that will be, Milord, at a page, Milord, at a glance before your lordship. Every statement is false. Every statement is false.
Basu will have to justify that.
I say false, false. Where are you saying sacrosanct?
But there's an adage in Bengali, Raja let them fight out, will not let my money be returned. My money cannot be withheld like this. I am not a very poor person. I had to take the money on loan.
I am not.
Whenever
This, let the bank and the other person, borrower, go on fighting. They will go on fighting for years. But why should I be kept on hold?
whenever I appear in these matters, either from this side or that side, I find
Mr. Basu, has nothing to do with me.
Yes, Mr.
There was no calculated sale was not come.
Since I'm hearing both
My
of
lord?
them together, I'll pass a composite order. Both have been heard together always. So instead of segregating one, passing one order, one.
Yes, that your lordship has been hearing.
Yes.
What loan should be given to Mr. Saptangshu Basu?
I have only paid because of delay. I have to bear the interest to the other bank. Anyway, lordship, kindly, if a lordship so desires,
next
do it, little early.
Next Friday.
Next Friday. Very well.
Is it possible any day except Friday? Contempt matters are there, my learned friend assisting me.
Friday, I also have my other all benches take up assigned matters usually on Fridays.
From 2 p.m.
Let's see.
Kindly issue a suo moto rule for contempt.
Against
This
me.
will also become a contempt
Against
matter
me,
against the bank's officer who has affirmed it.
Against me first.
This will also become a contempt matter.
I'll fix it in the first half.
Fix it, my lord.
My
Take
lord.
it. Time your lordship according to your lordship doster. Let us see.
Heard Mr. Banerjee, duto writ petition ei likhbe. Heard Mr. Banerjee, learned advocate appearing for the borrowers. Full stop. He is yet to conclude. List this matter for further consideration on 31st July. 31st July. 2020. No, 10:30 you want the whole board to be installed because only your matter is important. 12:30.
Yes.
Keep them like
30.
Great. No, don't go.
Next.
Sorry. I briefed them. দেখতে পাচ্ছি না একটা মনিটর না থাকলে অসুবিধা তৈরি এইদিকে না আচ্ছা I am for the plaintiff respondent, revocation of leave under clause 12.
Your Lordship, our application is listed today. Your Lordship, I'm being led by Mr. Rotnanko Banerjee. He's in a difficulty. So he was requesting if a date can be fixed. If 7th August, I understand.
7th August.
I understand it's only taken on Fridays.
Yes.
So if 7th August can be fixed.
7th August. 7th August. लिखे नहीं. An adjournment is prayed for on behalf of
Grateful. It's a Friday afternoon, my lord.
দিন 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 করে দিই, আগেও ছিল না, লিখে নিন, আগেও কেউ ছিল না দেখছি, লিখে নিন। None appears for the petitioner. The petitioner was unrepresented. Next.
That I appear for the High Court administration. We had on the last occasion filed the opposition with copy to the other side. They were not present. There was a resolution not to pass any adverse order. Matter was adjourned till today.
লিখে নিন। None appears for the petitioner. Full stop. You're there?
That it has been served on. May I get a short date because it's pending for now.
Next Friday, if it comments to your lordship.
31st.
31st is all right?
Yes, yes.
লিখে নিন। Affidavit in reply filed on behalf of the petitioners is taken on record. Full stop. A copy thereof has been served.
But item 5, my lord, I appear for the petitioner. May I be permitted to appear online, my lord? And for the petitioner, my lord, I'm praying for a short accommodation, my lord. We have to file a reply affidavit to the supplementary file.
May
by
I
the
object to
respondent.
that because they have already taken.
Yes, my lord. We're
this
seeking
twice.
an extension, my lord.
Nothing remains in
My
this
last-
petition. Nothing
last-
remains, my lord.
last
Prosecution
opportunity.
has been started.
File and reply like.
My lord, grateful.
Okay.
Learned advocate appearing for, you are for the petitioner?
Yes, my lord, for the petitioner.
For the petitioner. Seeks extension of time to file affidavit in reply.
Exception, my lord, to the
Acha,
report.
to file the exception. No, but the order was to file affidavit in opposition in reply. You want to file affidavit in opposition to the report. That was the order.
Yes, yes, my lord. Yes, yes, my lord. Yes.
Extension of time to file affidavit in opposition to the report. Within bracket, exception. করে দিন। Filed by the Deputy Registrar of Companies. Full stop. How much time you need?
My lord, if your lordships could give 10 days, my lord.
As prayed for, let such affidavit in opposition stroke exception be filed within 2 weeks from date. List this matter on 21st August 2026.
Deeply obliged, my lord. Grateful.
Well, we'll kindly record that this is the last opportunity given to them.
Not required. It will in any case.
Because nothing remains, my lord. That is why I'm saying, my lord. Nothing remains.
Very well.
My lord, one
So
indulgence.
good.
My lord, one indulgence, my lord. My lord, OD2, my lord. My lord, OD2. My lord,
What has
kindly,
happened?
my lord, kindly makes it not to the.
Why?
My lord,
Last occasion also you were not there. Today also you were not there.
my lord, today, my lord, there was some confusion, my lord. That's why, my lord, I couldn't appear. Kindly makes it not.
লিখে নিন ওতে ডিসমিস ফর ডিফল্ট যেটা হয়েছে Yes.
And item number 6, and for the petitioner's company at the time of filing this petition, his company was under CIRP, and the petitioner is a resolution professional at that time.
You don't want to press the writ petition. You want to withdraw it.
Yes, I mean, in fact, presently is the infructuous, my lord.
Fructuous or not, I don't know how it has become infructuous. Do you mean to say the show cause notice has gone?
No, my lord, the so-called notice has gone, but the resolution after approved of resolution plan, presently so-called notice under the resolution applicant, not for the resolution, not of the present petitioner, my lord.
What is
Your lordship, if she says that it has become infructuous and they do not want to press and withdraw the matter, we do not have any objection regarding that.
Where is Mr. Jhunjhunwala? He was leading you, isn't it?
Yes, madam.
Call him. You don't know the repercussions of what you're submitting, call him and then Passover বা not today করে রাখুন যদি হ্যাঁ
And we are paying for not today, my lord.
Take appropriate instructions. Once I dismiss it for non-prosecution or if it as infructuous, you will be in trouble. Be sure of what you're submitting.
Can I provide a client instruction through the mail?
If you have written instructions, give it, I'll dismiss it.
Okay, and on next occasion, I provide a client
You have challenged the show cause notice. Suddenly you say everything will revive.
instruction.
Understand the repercussions and then make submissions.
Grateful, madam.
Next.
Grateful, your lordship.
Okay, let's say
It,
জ্বালিয়ে দিন ইডি জ্বালিয়ে রাখুন সবাই জানতে পারে বাইশ আচ্ছা ওইটা হয়ে গেছে
Sorry, my lord. This is the Calcutta Club matter, my lord. I do not know whether they are appearing. The other side.
You'll have to serve again.
We'll serve again and come back. My lord, we'll do that.
লিখে নিন
Very short point, my lord. We have the notes ready. We'll argue, my lord, whenever it is.
Last time you were supposed to hand up a copy of the old act or something.
Yes,
as
my
I
lord.
recall.
Yes, my lord.
Sales tax or whatever. it is.
Yes, my lord. The Entertainment and Luxury Tax Act, my lord.
Luxury
Lordship,
tax.
lordship. Because that was a short point, my lord.
The tribunal's constitution has not undergone any
Not
change.
yet changed, my lord. Not yet changed. So the original order, my lord, which we had challenged before the tribunal, is before your lordship, my lord.
That I understand, but that was on the ground of the
The tribunal not functioning. Still the same.
Not non-functioning.
One of the member, my lord,
It's still the same
still the same constitution, my lord. That's the difficulty, my lord. That is why.
None appears for the respondent.
Item number 26 is my writ petition. The Lordship will see the last order. The state was directed to file a report, which is still date
Now
not
it
seen
will
the
be
light of the day.
Now
And
will have to serve the state because of the panel having.
yes, but then in such circumstances, because your lordship had already considered the prayer on the last occasion and had passed the order on 14th of May 2026. If your lordship kindly looks into the order.
I'll extend the interim order.
Yes. If your lordship kindly, just a minute, this is my
I'll
application.
extend it till the end of August.
Till the end of August?
In the meantime, you serve again because.
No, Judge, I'll extend. Yes, yes.
In the meantime, you serve again so that they can.
Yes, I understand because of the change of the regime, it could be a
It
problem.
will be for your benefit also, so that the matter can be taken forward from this point of time.
Yes. Otherwise, we
If
had
your lordship may
served.
kindly look to the last order, there was direction that I should serve a copy, and meanwhile the
My
parties
learned
could be
friend is
entitled to
jumping the gun. It is my writ petition. He is not even a party. There is a
It's not
connected
jumping,
writ petition.
all three are same matters.
But my writ
Let her
petition
complete,
is
my lord.
called on. Let me submit.
It's all right. Later.
And there was a communication. May I just hand over to your lordship? This is dated 25th of June 2026. Akbar Deven Didi. Ek to di.
हाँ, 26, 27, 28 सेम है।
This was communicated to
Yes. No, we have marked a copy. In fact, we have been marked a copy of this in June.
Means somebody is engaged.
Yes, somebody is engaged. But if your lordship so directs, we shall again communicate.
I'll record.
And
as per lordship's direction.
bole. Lordship was an report
None appears.
and then let it be.
from the communication which my learned friend handed over, that I do not know, all things are same. That state has not represented actually. Only apart from the communication, everything is same.
But in item numbers 27 and
27?
28.
What?
27 and 28, Lordship. Yesterday, I have been engaged on behalf of the KMDA.
Oh,
KMD.
KMDA
was
his representation may be noted, but actually the state necessity of state would be there.
From
Same
what I
order.
have understood that the stand of the KMDA has to be commensurate with the stand taken by
Actually, it's the main contest with state and KMDA. They have
has already filed its
Yes,
affidavit.
yes. I have checked up
Therefore-
the records, Lordship. Yesterday night I received the brief.
same order should go.
Same as 27.
27,
28
in all the three matters.
I will kindly see the records of 27, 28, whether there was any interim protection granted, because I don't think there was any such.
I have let him go through the order.
Very
This interim order was subsisting all along. And my learned friend is not a party in that also. Therefore, I think, he is not a party. The petitioner of 26 is not a party in 27.
On 18 June 2025,
To 28, there was possibly a direction that HMC may use its affiliate.
Your Lordship, there was an, Your Lordship, I was led by Mr. Sandipan Banerjee in this matter. He has retired from the brief, Your Lordship. I shall take instructions and come back, Your Lordship.
yes, if you want to file, you can come up. Even if there is no direction, that I'll permit.
Yes.
Not a problem.
Great.
Without affidavits.
It's now he has been engaged there for.
Constructing.
29, Lordship. I beg to appear on behalf of the petition.
But I am appealing for the respondent number 3 and 4.
No state. On the last occasion also, state had not appeared. So may I just serve and come back?
Taken in,
Notice.
none appears.
And we have track report is there.
Lord, I have instructions to appear, my lord. Can you not takes it up on next week, my lord? Lord, I have not received the Vokalatnama yet, my lord. And that is the whole
Monday?
difficulty. Monday, my lord, there are assigned matters before your lordship, my lord. On Thursday, my lord, kindly takes it up.
Thursday, very well, लिखे नहीं. Affidavit of service filed in court today is taken on record.
One lordship, I beg to appear on behalf. 31. Didi.
31. Was he a Madras?
কিছু চালান গরম
31 তো 31 ই তো আমাদের
31.
Under the petitioner is a defendant in a suit for declaration of shares, lordship.
Yes.
Lordship will kindly take up the impugned order. The petitioner filed an application under Order 7, Rule 11, primarily on the ground that the suit is barred by limitation. Because lordship, the cause of action admittedly in their plaint, they have written that the cause of action arose sometimes in 1982, and they have filed the suit in 2021. In 2022, lordship, an application under Order 7, Rule 11 was filed on behalf
Where
of
is the plaint? Show me.
plaint. Lordship will find at page 27. That is the first paper book, lordship.
Page 27, yes. Show
Page
me where.
27 marked as Annexure P1. Lordship will kindly turn over to page 37. Page 37, that is paragraph 25. The cause of action for this suit commenced in 1982, when the succession certificate in respect of debts and securities left by the plaintiff's father, Prakash Chandra Kundu, was granted to the defendant number 1 and continued since then. So, lordship, this is their statement in the plaint that they say it started in 1982. Persistently resisted and denied to hand over respective shares to the legal heirs of the late Prakash Chandra Kundu, including the plaintiffs, and received and utilized for his sole benefit the dividends and interest accruing therefrom. On 31/8/2019, when this learned court passed the judgment in title suit number such and such on 5/12/2009. So this is a suit, lordship, which my mother had filed against me. These persons who are the plaintiffs presently, lordship, they were arrayed as private respondents in that suit. They went ahead, they just made a contention that no,
What is this suit for?
lordship, this suit, lordship, they have now claimed that they are entitled to 1/10 share in the shares left by shares and dividends which have been left by the present of the party's father. Lordship, in 1981, lordship, a succession certificate was obtained by my client, who is the petitioner before your lordship. In that succession certificate, lordship, the mother of the petitioner, who was a plaintiff in the previous suit which has been referred to here, and lordship, these persons who are the present plaintiffs, they had all consented to that. It was all within their knowledge since 1982 that I have been given a succession certificate by a competent court, and I have been in possession of the shares that have been left by my father. Now, lordship, in 2007, my mother filed a suit claiming her 1/5 share along with my elder brother. They claim their 1/5 share. court decreed in their favor. And that was only restricted to the two persons who had come up before the before the learned court below with regard to their 1/5 share each. These persons, although they were arrayed as pro forma respondents in that suit, Lordship, they did not contest the suit, they did not file a claim before the court then that they are also entitled to something. Now in 2021, these persons come up and file this suit. I take out an application stating that it has all along been in their knowledge, since it is their categoric admission that the cause of action arose in 1982, they have also consented. If my lord, if I show my lord the succession certificate, it is written there that they have consented to the succession certificate being granted in favor of my client. Court, in disregard of that, Lordship, just mechanically noted down the provisions of Order 7, Rule 11, and Lordship said that the matter may be sent for trial, or Lordship fix for hearing of the injunction application on the next. May I place the impugned order?
I'm just going through it, not
Lordship. David?
When is the next date fixed?
Next date today was the next date fixed, Lordship.
Today it's over. What has happened thereafter?
Order 41, Rule 1 file করেছেন our side.
An application under Order 41, Rule 1 has been filed by the plaintiff. সেটা কি application?
Receiver application.
Receiver. That
is Order 40.
Order 40.
41 is appeals.
Yes, that is why I asked key application.
Seven come. He has not dealt with the limitation aspect at all. This because we can. Taken in.
Next date is on 1st of August.
Forty-four item number, interim order expect today I mentioned with my lord.
Very well, I'll take it up.
I'm for the my lord, expeditious hearing, my lord. The all the petitioner are my lord senior citizen, my lord. My lord, kindly see the order dated 13 June, my lord. DW started, my lord, but yet 1 year already, my lord, passed. DW has yet.
Item number 34, Mr. Devabrata is appearing for the
Not
petition.
today.
My only on one point I just like to refer it before lordship.
He is
My
pleading for adjournment.
No, no, I am-
unnecessarily. Mr. Dr. Sahara, we are running short of time. Extensions
But
are
district
also there.
magistrate should be made a party here.
Very well, he will make it on the next day.
Then can it be on Tuesday subject to lordship kind of?
Well, if you're not there, pray for an adjournment.
I will.
Call for
35 ওটাই
35 praying for not today.
not today. Correct. Extension গুলো কল করে দিচ্ছি হয়ে যাচ্ছে आगे खुले
36, 38, yes, my lord. Yes, my lord, I appear for the petition, my lord, for extension of order dated, my lord, 1st May 2025. It was extended till July end, my lord.
The opposite party?
My lord, then
Where is the affidavit of service?
service police, affidavit service আছে?
लिखे नहीं? None appears. একসঙ্গে আছে? ঠিক আছে। There is a combined order.
Yes, ma'am.
Right. 39, my lord, interim order till this month. My lord, filed affidavit of service, my lord, showing service upon the respondent.
Affidavit of service. আগেরটাতেও তাই করে দেবেন, monthly list of August.
I appear for the petitioner, my lord.
I am appearing for the opposite party.
The interim order is till the end of this month, my lord. Kindly explain.
Last time, this matter was fixed by your lordship, but in the meantime, determination has changed. My lord. No. It is the irony that this matter could not be get heard by your lordship.
Having heard the learned advocates appearing for the respective parties, comma, the interim order granted earlier is extended till the end of August 2026 or until further orders, whichever is earlier. List this matter in the monthly list of August 2026.
Let it be kept with the record, my lord.
He is appearing. Next.
Grateful.
Next. এলো না তো, নট টুডে করে রেখে দিন। নেক্সট।
Time for the petition.
ফাইলটা বের করে রাখুন, ভেরি গুড।
This is my.
None appears.
This is my affidavit of service.
Appearing.
Even though is appearing for the opposite party, he is on late before the courtroom number.
Very well, I am extending the interim order, it will appear before.
Yes, sir.
Having heard the learned advocates appearing for the respective parties, comma, the interim order granted earlier is extended till the end of August 2026 or until further orders, whichever is earlier. Same order. Next. Same order. Having heard. Next.
Law about the petitioner. This is my every service. Interim order till end of July, my lord.
Then why are you worrying? You said it is going to expire today till the end of July.
My lord, just now I have seen, my lord, after my junior.
Your Lordship, I am appearing for the respondent in item number 44. Your Lordship, I have only one submission today. Your Lordship, let the interim order be extended, but Your Lordship, I have to pay the interest for the problem of the petitioner. So, Your Lordship, a date to be fixed for hearing of this matter. Otherwise, the insurance company will have to pay the interest.
I don't have the regular determination for this. I'll extend it for a limited period.
Yes.
So that once it comes again for extension, you can argue it out.
Yes.
One on the original side. Having heard the learned advocates appearing for the respective parties, comma, the interim order granted earlier is extended till 21st July, 21st August 2026 or until further orders, whichever is earlier. List this matter in the combined monthly list of August 2026.
May I get your
affidavit of
May I
service
get your lordships?
is taken on record.
May I get your lordships kindly to mention one matter, my lord?
45, my lord, I am appearing for the petition. My lord, I have served, my lord, the interim order is up till.
Somebody is rushing in. He's there.
So he is, my lord, appearing with myself. Affidavit of service, my lord, I am also filing.
Taken in affidavit of service. It has returned.
Yes,
envelope return.
Left.
For return money.
With the endorsement left.
Affidavit of service filed in court today is taken on record. Full stop. The postal articles sent to the opposite parties have returned with the endorsement left. Full stop. The petitioner shall serve a fresh notice on the opposite parties. Full stop. Comma, and file affidavit of service on the returnable date. Full stop. What happened?
It's an application for restoration, my other side, Mr. Lan, senior friend. Appeal. I'm equipped with the affidavit of service. Your other side?
Your other side?
Your other side was here, sir, my restoration, sir.
The lordship,
47, affidavit of service, madam. Restoration dismissed on. Oh, अच्छा, 46.
Your lordship, I'm appearing for the petitioner. My lord, I'm seeking an adjournment for today's.
Not today, not this. Next.
47. Restoration application, dismissal on 24th of February, application filed on 2nd of March.
Lordship, in this matter, I am instructed to appear on behalf of the respondent CDCL.
Restoration application.
Lordship. And later copy may be served.
Copy of the application.
ACDCL. ও আমাকে বললো
My current
affidavit of service
earlier occasion
filed in court today is taken on record. Full
Advocate Commissioner for Order 26, Rule 1 and 4.
Yes.
So this is
That was not the only ground for dismissal. That was one of the grounds. Suppose I accept that ground.
yes.
What about the other grounds?
Other ground, Your Lordship, directly, Your Lordship, Order 26, Rule 4.
Yes.
The other ground was
Paragraph 6 also.
paragraph
You have
6,
attended the
yes,
court, you
are
have
not
attended-
invocable by the litigant or witness.
Wait for the court to conclude. Please read paragraph 6 of the order.
Yes, Your Lordship, at Alipur Judges Court, December 9, for the purpose of affirming the affidavit in support of the said application.
Yes.
Your Lordship,
So
after
if you can go to the court for
that is for
you can attend court for the purpose.
that is for one time, Your Lordship. Kindly let me.
So one time only we'll go for additional
No,
evidence.
no, Your Lordship. After applying to the apex court, I did get 10,000 rupees for commission, 3,000 to 4,000 rupees, Your Lordship. That by taxi, and Your Lordship, one part. Order 16, Order 26, Rule 4 provided that where under Order Rule 19 of Order 16, a person cannot be ordered to attend a court. Order 16, Rule 19, no one shall be ordered to attend in person to give evidence unless he resides.
Where are you reading? What are you reading?
Order 16, Rule 19.
Reading the statute.
Yes.
I thought I was reading the order.
Order 26, Rule 4. Thereafter, continuation to Order 16, Rule 19.
Yes. Order?
Order 16, Rule 19.
Order 16, Rule 19. Yes. Rule?
Order 16, Rule 19.
Yes.
No one shall be ordered to attend in person to give evidence unless he resides within the local limits of the court's ordinary jurisdiction or without such limits, the other party. So, Your Lordship.
So what? How is it relevant for your purpose?
I am not living within the local limits of the jurisdiction, Your Lordship. I am in Bhawanipur Police Station under, and this is Bankshal Code, Your Lordship, ordinary jurisdiction, Your Lordship.
So,
Your Lordship.
the other ground I am accepting. You went to Alipur court it is not a luxury. Somebody's blood pressure has risen, therefore
Blood pressure, hyperglycemia, hypertension, both are there, Your Lordship.
Those are all for a moment, for 1 month it was there.
60.
Thereafter
not reviewed. Thereafter 1 month, after 1 month it was told.
Reviewed, you had to bring
reviewed.
it on record before the trial court. Who will bring
Money
it
is a factor, Your Lordship. Every time for commission, 3,000 rupees, 2,000 rupees.
You can go
for affidavit for only 1 day.
The affidavit before the notary and you will not face the doc. That is not the law. This I can understand.
But
there is a mistake
this is
of court. I will accept it. I will
Your
match
Lordship,
that,
Order
but
60.
the conclusion still remains the same.
Grateful, Your Lordship, but this Order 16, Rule 19 in mandatory, if I am not wrong, no one shall be ordered to attend in person to give evidence. That part only, Your Lordship. Kindly consider that part. And
Considered it.
and Your Lordship, one maxim is there regarding one departure from the original, from the general provisions. A verbis legis non est rescindendum. This means from the word of the law that there is.
What are you reading?
Yes, your Lordship, that part, Order 16, Rule 19 is mandatory part. So only on that part, Order 26, Rule 4, if I am praying for commission, so that part, kindly consider that part, Order 26, Rule 4.
Very well.
And there are other medical elements as well that has been submitted in the affidavit of assets and liability. So
the application contained only this prescription.
Yes.
Nothing else.
Yes.
The court had taken note of that. The court had also taken note of the fact that is the trial court's order. The trial court's order says that you were there before the court. You had affirmed an affidavit.
Trial court didn't hear. My application was rejected on the same day, Your Lordship.
So what? There is a bar on trial court taking up the. Suppose I take up your application.
Didn't hear me, Your Lordship.
On the same day. Will that be a ground for challenging the order? That can't be a ground. It is good that the trial court has been prompt. If it had allowed the same day, you would not have been aggrieved, isn't it? So merely because it is rejected on the same day, that is no ground. You can say that he has not considered your submissions or he has wrongly considered your submissions. That is a good ground.
Grateful.
You can indicate, you have indicated, yes, I accept this is a mistake. I have passed a wrong order so far as paragraph 5 is concerned.
Grateful.
I will.
And para 6, para 6, your lordship, order 26, rule 4. That part, order 6, continuation is order 16, rule 19.
Very well, I'll consider. Come on Monday. I'll pass my orders on Monday. এটা সোমবারে রেখে দিই। তো ওইভাবে করবেন না, আপনাকে সব একসঙ্গে দিয়ে দিলে তো হবে না, খুঁজে দেবেন ঠিক করে। ইয়েস।
My lord, 49, I'm for the petitioner, my lord. I filed an application for recalling of the order, my lord, past ex parte without serving any copy to us, my lord. My lord, the matter has been projected in a manner that as if in a eviction suit, my lord, the ordinary, my lord, eviction suit, normal procedure is going on, and deposit of rent has been made, and he wants to withdraw the rent amount. But here in this case, my lord, we file a counter claim. My lord, a counter claim. My counter claim case is that since, my lord, since there is a high tension line and line has been disconnected, I am.
You will serve a copy.
Yes.
On the other side. Serve a copy. on
Next,
the-
my lord, that is, he has already, during pendency of this application, he has obtained already order for, my lord, payment. So that's why, my lord, and then next week kindly a date may be fixed.
Very well. लिखे नहीं? The petitioner shall serve a copy of the revisional copy of the
Time, my lord.
Upon the 21st. Well, they are-
अरे बाबा जान जोसेफ ना
Instead of 7, well,
বললেই সব দেবে
21st you have
বলেছি
My lord, I am appearing on the matter where it is being mentioned, my lord.
21st.
21st of, my lord, 21st of
August.
August.
Was July.
May I have your lordship kindly, under a very compelling circumstances, I have to again mention, your lordship,
31st July. না আপনারটা নয়, ওটা original.
your lordship, after filing, we have got, lordship, after filing, we have got a date of Wednesday, your lordship. Can it be there on Monday, your lordship? That's all why I'm praying. Your lordship indicated me in the morning to file and come back. Your lordship, I filed the matter, your lordship, we have got the filing number also. Just the matter has been listed on.
In the meantime,
Your lordship, I am praying for Rule 26 leave, your lordship. Your lordship, there is circumstances. There is circumstances. I'll show on that day, your lordship. Under very urgency, your lord.
It is very, very crowded.
My lord,
Lordship, we'll serve and come back on Monday. We'll serve and come back.
my lord, I was praying.
Can
for
it be listed on Monday, your
I
lordship?
was praying for leave to file a civil revision